morning, everyone, and thank you for your patience. This is the first meeting of the Special Committee on Criminal Justice Reforms. Will the clerk please read the title of the resolution?
Resolution 160101, appointing members to the Special Committee on Criminal Justice Reform who will conduct public hearings examining the Philadelphia criminal justice system for the impact of current policies and offer recommended strategies to reform that are in the best interest of public safety and the public good.
Thank you very much. And we would like to have the President of City Council, Darrell Clarke, who created this committee, say opening remarks to set the tone for what we are about to embark upon. Council President.
Thank you, Councilman. First of all, I'd like to say thank everybody for agreeing to participate in what we believe that will be a fruitful and a very progressive approach to criminal justice reform. I'd like to start by saying I want to commend all of the members and the stakeholders that participated over the last year in ensuring that we got the MacArthur grant. It is clear there was a lot of good work put in that process, particularly given the level and the type of award that was made. I do believe it was the largest one of all of the municipalities across the country. So I want to commend those people. And again, it shows what happens when people work together. We can achieve some things. This particular committee will hopefully build on that process. And now that we actually have some resources, i.e. financial, to be an assistance to the committee, I think that it will only enhance our ability to move forward. Really excited about the possibilities. This will give, over a period of time, understand the committee has established a number of series of meetings, some off-site, that will give the people of the city of Philadelphia and the surrounding areas an opportunity to weigh in on this very, very important process. This is probably one of the only issues that the Republicans and the Democrats agreed with in Washington. So that tells you how important this is. This is truly an issue that will be a bipartisan approach. So I want to thank the chairs and thank all of the members of the committee so much for their willingness to serve, and we look forward to some really good work coming as a result of that. We will, throughout our budget process, depend significantly on some of the reports that are coming out in terms of making sure that the city prioritizes those issues and initiatives that will make sure that this is a successful effort. So, Mr. Chair, thank you so much, and I will officially step off from the process and let you all do what you do. Thank you.
Listen, we want to thank you again for having the foresight and vision to bring us all together, to put together this level of expertise to drill down on such an important issue. And we want to thank you for empowering us to go about our business to kind of tweak what exists to make it even better for the citizenry of Philadelphia. And I just want to thank you publicly.
Thank you. Thank you, sir.
Okay, so his first edict was that an elected official politician should not be the moderator for today, and I think that is his first and wise decision. I want to also recognize that we have Senator Vincent Hughes in the audience and has been a proponent of change not only in his district but in the Commonwealth. I want to thank you for stopping by for this maiden committee's voyage to make it better. Thank you, Senator. Would our moderator, Chief Defender Care Bradford Gray, please take the podium and begin us. She was already there.
Thank you, Councilman Jones. Good morning. I want to really thank, again, President Council Clarke for doing this. I think that this is an effort that's being engaged in all over the country, and we are now seeing the intersection of criminal justice, stakeholders, and government coming together to figure out how to be what we call smart on crime. And Smart on Crime is an initiative that's not it's a new term, but the concept is not new. And what that means for government, as far as being smart on crime, it means that we're going to be taking a citizen-centric focus, a social justice that fosters social justice, civic engagement, activism, and transparent and accountable governance. Our local government knows that they have the responsibility to do more that works and less of what doesn't. So the panel discussion will give you an overview of our criminal justice system. Our panel comprises of a variety of stakeholders that work together to achieve a system that is fiscally responsible. That means we use taxpayer dollars wisely. Fundamentally fair, one that ensures that people are treated fairly by reducing the bias within our system, and one that promotes public safety. Are we making people safer by the policies that we implement and by the policies that we practice? To maximize the effectiveness of the special committee to achieve meaningful reform, there needs to be an open and integrated relationship with the various agencies that make up the criminal justice system, city government, and of course, the citizens of Philadelphia. We hope this discussion will be the first of many that will bring forth recommendations regarding budget redistribution that could rebalance responsibilities. Really what we've been seeing now is the criminal justice trying to focus and trying to deal with social ills that many people on this panel believe they're not as equipped to do it as other professionals. So we're hoping to look at those areas where we are dealing with issues that we are not really completely, solving those problems. And in that respect, we hope that we will return some of the duties and responsibilities to the professionals that are in the healthcare system, social work, schools, and organizations that understand the social impact of poverty and, of course, education not being properly funded and provided to our youth and to some of our young adults. So I want to especially thank Councilman Curtis Jones for taking an active interest in our criminal justice system. You've immersed yourself in what our system is. It's in all of its complexities. You've done a wonderful job. But of course, also a special thank you to Stacey Graham for organizing this committee and doing all you can to make sure that these public hearings are as robust of a discussion as possible. So we'll get forward with the presentation, but I want to just talk to you a little bit about the system and give you an overview. I know going through this process, we all are criminal justice stakeholders and working in some area of the criminal justice system or another. And it's so funny that even we don't understand all the moving parts that make up our system because it's so large and complex. So what I did is put together a PowerPoint to give you just a brief overview of our systems process. And we're going to talk about areas that obviously where we have some challenges, but we're also going to talk about where we are actively working to reform those areas to meet the goals that I described just a few minutes ago. So to start with this one, we will talk about obviously the first point of contact will lead you into our criminal justice system, and that's contact with law enforcement. And in law enforcement, contact with law enforcement, there are several options available to law enforcement. Now, these things are not as well known to the public, obviously, because if you don't interface with law enforcement in this respect, you will not see how that works. But law enforcement has the opportunity to issue a summary citation for the behavior that they observe. They have the opportunity to notify crisis response centers for certain behaviors that they are called to deal with, and of course, arrests. We generally hear about the arrests and we don't hear about all the other things that law enforcement does to keep people out. And we have Kevin Bethel here today to kind of discuss in a more robust fashion some of those options that are available to him and some of the things that he's already been implementing to help with one of our goals for our justice system to be fundamentally fair and fiscally responsible. After that, if you are given a summary citation, you have a few things that are available to you as well. You can go to trial, you're possibly diverted into a program, or you are assessed a fine and a fee, and that's for a plea of guilty to the summary citation. You can change it, Stacy. Of course, if you're arrested, and there's some opportunities before an arrest is made, and that is really at the law enforcement officer's discretion. You will have what we call a pre-arrest diversion program, which and Kevin Bethel is going to talk to you a little bit more about the ramifications of a pre-arrest diversion program, if there are some citations or if there is a record that is generated because of that, and we'll talk about how that helps to achieve some of the goals that we're looking for in criminal justice reform. But if you are arrested, a complaint is then filed, and then you go to what we call a preliminary arraignment. Now, preliminary arraignment is held in a criminal justice center. It's open 24 hours a day. And for the most part, the public defender office does represent about 95% of the people going to formal arraignment. Preliminary arraignment. There are opportunities for private counsel to make representations at that time, but the public defender is the one primarily handling that duty, and Mark Holden from the Defender Association will talk about how we are going to reform our efforts to have a more robust discussion or a more robust representation at that point. After the preliminary arraignment, you will go to what's called a pretrial supervision, and that's where pretrial will come and assess your abilities to either afford your own attorney or make sure that you are represented by a court-appointed counsel or a public defender. You have some options when, after you're assessed counsel, as to what's going to happen for you. They will either detain you, they will either let you out on your own recognizance, or you can get out on a sign-on bond. Those things can be discussed from members of this panel who are very familiar and aware of those options and can talk to you a little bit about what we are doing, of course, with the MacArthur initiative to change that process, to change our reliance on cash bail, and to look at what we need to do to funnel people in different directions of intervention rather than detaining them. If your case, and this is the next slide, if your case is determined to be a misdemeanor, you will go through what's called our municipal court process. And in the municipal court process, there's also options for diversion. That will be the district attorney's office. George Mosey will talk to you about the diversion process and practices and what determinations go into that. You have then the option, if you're not eligible for diversion, to take a trial. And in municipal court, you do not have a right to a jury trial. What we do in municipal court is bench trials. That's where you sit in front of a judge alone and they decide your case alone. If you don't get the result you desired in that process, you always have the ability to appeal to the Court of Common Pleas, where you do have the right to a jury trial. Many people don't know that, and it's really a practice that has been going on forever, but it can be unique to Philadelphia because I worked in many counties and we don't have a municipal court practice. Everything goes straight to the Court of Common Pleas. But in Philadelphia, in an attempt to kind of keep the system flowing, we have these different parts. If you don't elect to go to trial, your other option is to plead guilty, and from there you will be sentenced and assessed accordingly. If you do take a bench trial, you can be found one of two things: not guilty. Like I said, you're guilty and you appeal to the Court of Common Pleas to ask them to redo your case, and then you can plead guilty, where you have no appeal to assess your case as to whether or not it was meritorious. If you are charged with a felony, you will go to what's called our Court of Common Pleas track. And in Court of Common Pleas, again, there is a diversion process, but also you will have an opportunity to get what we call a preliminary hearing. Now, a preliminary hearing is not a constitutional right. It is a local rule that allows a judge to assess whether or not there is probable cause to go forward with your case. This is a way that we continue to be fiscally responsible with tax dollars, so that we're not just sending every case through the system if there's no merit to it. At that time, the judge will assess whether or not there's enough evidence to go forward, and that determination is a burden. Basically, is it more likely than not that this actually happened in the fashion that the Commonwealth has said it happened? There's also an option that the Commonwealth may elect to use, and that's called a grand jury. That's where you do not get a preliminary hearing, but members that convene look at the evidence and decide whether or not there's probable cause to proceed through the Court of Common Pleas with your case. We have two different sections of our Court of Common Pleas. We have what we call felony waivers, and that's where cases that are more nonviolent and don't carry I guess the term we use is, we call it major cases. These are cases that have, dangerous weapons involved, or a real major crime that threatens public safety, such as kidnapping, robbery, certain crimes that are committed with weapons and guns. These more so go to what we call our majors program. For our felony waivers program, those are generally your felonies that are not necessarily considered violent, your drug dealing offenses, some car thefts, some retail thefts that carry a certain amount of money, and as well as other economic crimes where the amount of money is such that it will go to the Court of Common Pleas jurisdiction. So that is kind of the overview of the two distinct court processes in our system. And if you, Stacey, if you go to the next option. Now, of course, once you're going through our system and you're found not guilty, you're free to go, and you can file for a rightful expungement, which most people do not know and most people do not do, which they should do. But if you are found guilty of your offense, then, of course, the judge has the option to sentence you to a number of sentencing options here. One would be time served. That means if you are in custody the whole time until the duration of your case, the judge can say you've served your time based on the facts that I've listened to and based on the information that I've reviewed about what you need, and I will give you what I call time served. You have the option, the judge has the option to sentence also probation, a person to probation. They can give you time served with a probation tail, or they can give you flat out probation, where conditions will be put in place to address your needs and to make sure that you are rehabilitating. Parole is a form of supervision that generally comes after a state sentence is imposed. So if you have a county sentence, we call county sentence those people who will be serving their sentence up in our state road facilities, you will get probation generally when you're released. If you serve a state sentence, something that will send you out to our state facilities, Graterford and other ones around the state, you will be put on a period of parole once you are released. And it's a really complicated process, but generally in Pennsylvania, we have a minimum and maximum sentence. If you serve your minimum and your paroled, you serve the remainder of your sentence up to your max on parole, and then you can then you'll start your probation period if a probation period is assessed. And of course, like I stated before, incarceration, we can use our county options or our state options, and that is basically determined upon your record and what the offense you've committed. So once you're on, and the judge obviously will assess whether or not there needs to be some restorative practice or restorative sanctions placed on you. If there are any issues or related to someone's property damage or financial loss, the judge will assess what we call restitution on the person that has committed the crime. And then also fines and costs are assessed in every case where someone is found guilty, because those, and I think Rich McSorley could talk a little bit more about what fines and costs go to and how that came about, into figuring out what funding sources those things go to. County probation and parole, of course, has a lot of different channels. A person on probation or parole will go through that probation period, and if they complete it successfully, they are released. But if they do not, there are certain kinds of violations that will bring you back into court and bring you back into the purview of the judge and, of course, the probation department's recommendation as to what to do with you. And those are called technical violations, meaning when you do not follow some of the conditions that were placed on you, you can be in terms of a violation, it would be called a technical violation. If you commit a new offense or are accused of committing a new offense, generally that would be called a direct violation. And we have what's called a Gagnon 1, where if you're in either of those violations, technical or direct, we have the ability to review what you've even done or what you're accused of to determine whether or not you should remain in custody or you should be out until a full-fledged hearing is assessed to your behavior and whether or not this is something that you should be found in violation of. So once you go in front of a judge on a hearing based on a violation of probation, the judge can find you're not in violation based on the explanation put forward. The probation and parole can be continued because they figure that intervention will help you complete your probation successfully. They can give you a new form of probation if they feel like you need a little bit more time to help get some of the struggles that you're dealing with in order. They can put you in incarceration. They can incarcerate you if they feel like this is something that is going to be necessary for public safety and protection. They can give you what we call back time. That is the time you did not spend in jail based on your minimum and maximum sentence. Or they can give you no further penalty. So generally, that's the way our system flows. There is so much more to it than that, but I just wanted to kind of give you that general overview. So when we have this discussion, we can talk about some of the intersections where we're looking to provide reform efforts. I will introduce members of this panel so that you understand exactly who it is that will be discussing some of the information. First, we have John F. Holloway. He's the Associate Dean and Executive Director of the Quattrone Center for Fair Administration of Justice at Penn Law. John has done extensive research on systems nationwide and has definitely helped with his research in academia to figure out where we as a system in Philadelphia can maximize our reform efforts and make recommendations so that we can kind of be more progressive in our efforts in keeping up with national trends and policies. Kevin Bethel, Senior Policy Advisor, formerly of the Philadelphia Police Department. He is working with the Stoneleigh Foundation. He's a fellow, and he does juvenile justice research and reform. Richard Podgorski, sorry. He's the director of the Bureau of Reentry Coordination and Pennsylvania Board of Probation and Parole. Mark Holden, Director of Policy for the Defender Association of Philadelphia. We will have joining us shortly the Honorable Benjamin Lerner, Deputy Managing Director for Criminal Justice. We have Mary Catherine Roper, who is the Deputy Legal Director of the ACLU of Pennsylvania. Curtis Jones Jr., 4th District Councilman and Chair, Committee on Public Safety. George Mosey, 1st Deputy District Attorney, Philadelphia District Attorney's Office. Sharon Dietrich, Litigation Director of Community Legal Services. And Myron Patterson, Deputy Commissioner of the Philadelphia Police Department. So we have a number of cross professions and, of course, perspectives and vantage points. And I think this is going to create a really good discussion about our efforts today. Now, I will start by saying this. We have a lot of challenges in our criminal justice system, there's no doubt. But we want to make sure that we bring attention and start a discussion on some of the reform efforts that we are working towards so that people do have an understanding that we recognize our challenges and we are starting to do something towards it. And we want to make sure that we have a dialogue with members of the community and, of course, all of the stakeholders on how we can do more of what's working and less of what's not. So I will start this discussion with John Holloway. And John Holloway, could you talk to us about your work in evaluating systems and, of course, some of the goals that I've mentioned, what are the practicalities of those goals, and how do you come about some suggestions to do so?
Excuse me, Madam Chair?
Yes.
For those committee members that are not at the table, feel free to sit at some of my colleagues' desks. The only housekeeping, if you want to speak to be recognized, you have to push the button and you'll see the red circle come up and you're able to be recognized by the chair. So you are officially, for the next couple of hours, unofficial council people. Thank you, Madam Chair.
Thank you, Councilman Jones. And this is a discussion, and while we've broken it down into certain areas, if anyone has any knowledge or expertise in an area that we're discussing that can talk about some real practical reform efforts, I would love for you to join in that conversation and discussion. John Holloway, I'm sorry.
Thank you. Is it Madam Chief Defender?
I guess.
I want to thank Council President Clark, Councilman Jones, Senator Hughes, and the other members of this committee. It's an honor to be asked to participate, and it's an exciting opportunity, I think, to hopefully do some good for the city of Philadelphia. So thanks very much for allowing me to participate.
Thank you for participating.
The Quattrone Center was founded in 2013, and the idea was to create an interdisciplinary research and policy center that would look at criminal justice as a system and do data-driven research that would work in collaboration with criminal justice professionals to create thoughtful recommendations that could actually be implemented and create real-world change to improve our criminal justice system. We have a group of four, 2 lawyers and 2 economists working full-time, and an affiliated faculty of 12 that includes economists, statisticians, criminologists, psychologists, medical doctors, and others to bring both inside and outside perspectives to bear on important issues of criminal justice, and in particular what we call a systems approach. And what we mean by that is looking at criminal justice as a system. Certainly when we operate as lawyers and when we litigate cases, we have a tendency to make comparisons about individual cases, and each of those cases is important, but by raising it up a level and looking at the aggregate impact of what our actions have on a community and generating data that will inform people about how that's working in the aggregate, we believe that we can get additional views and additional insight into the system that will allow for useful and important reforms. So what I'd like to do, looking at the first slide, and I should say, for those of you who have a handout, my fault, your handouts are missing every other page. So you may wonder, hey, where'd that slide come from? It's not in my handout. I'm told it will be posted online, and if not, at the end of this, my email is here, and I'd be happy to provide you with a full copy of the slides. So the first question that I often get is, well, is criminal justice really a system? We've got police, we've got prosecutors, we've got the defense, we've got corrections, we've got probation and parole. Are they really all working together? Our contention is yes. Criminal justice is a system. There are subsystems within it. But the question that I would ask is, first let's back up and say, what is a system? Well, a system is any collection of related parts that interact for a particular purpose, okay? And so, next slide. If we think about criminal justice as a system, this is a single slide that takes most of the slides that the Chief Defender put together and runs from crime all the way through to sentencing. And if you can't read this slide, don't worry about it. That's really not the point. The point is, it's a complicated system.
Very.
And beginning with the commission of a crime, going all the way through to sentencing, there are dozens and maybe even multiple dozens, perhaps even hundreds of people who are making decisions about an individual's path through the criminal justice system that influence what is going to happen between crime and incarceration. One of the important things about the system, and this goes to what we need to reform the system and why this committee is so important, is that in any of these systems, each of the participants in the system is affected by the upstream and downstream actions of that system. And so one way to illustrate that would be to point out that the cases that a prosecutor's office is able to bring are due in large part to the arrests that are made by a police department. The arrests that are made by a police department are influenced by the cases that a district's attorney's office is willing to charge. And so you can see the back and forth in the system. It extends more broadly than that. An individual's decision to plead guilty, in large part, will be based on the charges brought by the prosecutor. That may be influenced by sentencing policies and legislation that creates different sentencing and different abilities to pack charges together, can impact all the way back early in the police departments or in the plea bargaining stage. So we can see this flow back and forth, and decisions that are made in one area of the system necessarily then have a ripple effect through the entire system. That's important because as we propose reforms, it will be important that we understand what those ripple effects really are so that we know what our reforms are going to do, and that requires the cooperation of all the people at this table and on this commission and throughout the different agencies in the system. And that's one reason why criminal justice reforms have been difficult to implement effectively, is that it's been challenging, particularly given the adversarial nature of the criminal justice system, to agree on what we want the system to do. Next slide. So I want to suggest for a second that we think about criminal justice as a system where what we really want to do is have a safe and crime-free community that's operating on principles of fundamental fairness. I'm hopeful that those are principles that everybody can agree upon. It's important that when crime is committed, it is addressed. It's important that people have personal safety and protection of their property. It's also important that when we run people through the criminal justice system, we treat them with respect and dignity, that we get it right when we're adjudicating guilt and innocence, and that we treat like people the same, that we not create disparate communities who get different treatment for the same conduct in the criminal justice system. And so that's what the criminal justice system at its highest level, I think, is designed to do. Next slide. This is a picture of the industrial definition of a high-quality system. So this is from the International Standards Organization, and it's a question of any system. What defines a high-quality system? And there are functionally three parts to a high-quality system. The first part is the requirements of the system. Does it do what it is designed to do? So a car that is designed to have a way of stopping that doesn't have brakes is not an effective system, right? That's not working. Does the system do what it's designed to do? And that's the left-hand column there. On the right-hand column, there's a second aspect to it, which is that the people using the system have to continue using it. So it can be thought of as a customer service approach. So again, if you make a car that does what it's designed to do, but nobody wants to use that car, it's not a very effective system. And similarly with criminal justice, when we run people through the criminal justice system, one of the key questions is, do they feel that they've been treated fairly? Have we reached an accurate result? And are we keeping people safe? In the middle is a feedback loop. And the constant improvement of a system involves designing requirements, getting feedback from the people who participate in that system on those requirements, and taking that feedback and incorporating it into change in the system. In a sense, that's what this committee is doing right now. We've received a lot of comments through a lot of the system about areas throughout the system where we could do better, and we're trying to incorporate that feedback into improving the criminal justice system. Historically, the criminal justice system has not been very good with its feedback loops, and it is a difficult thing to implement those changes. But that's what the task is. The task is to figure out what we want the system to do, compare it to how the citizens of our city are using it and benefiting from it or not, and incorporate their suggestions for improvement in thoughtful ways. Next slide. So I think the invitation for all of us as citizens of the city is to put yourself in the position of the Chief Executive Officer of Criminal Justice, Inc. And the job of Criminal Justice, Inc. is to unite the various product managers, whether it be law enforcement, the district attorney's office, the defender's office, community legal services, et cetera, all the way through corrections, probations, parole, and assemble the heads of those service lines, if you will, to define goals and set targets for how we're going to change things in the system. One of the really exciting things about the MacArthur proposal, which we were honored to be a small participant in, is that it has set a target goal across all of our agencies to reduce the number of people incarcerated in our system by 34% over 4 years, correct? 5 years?
Yeah, 3.
3 years. That's exciting because we've come together as a system, defined an attainable goal, set a target, and now we're going to work in concerted and coordinated fashion towards that. That's exactly what we should be doing. The Quattrone Center is also coordinating a group called the Philadelphia Event Review Team that has the voluntary representation of the DA's office, the police department, the Court of Common Pleas, and the Defenders Association that's operating a different kind of feedback loop where we look at individual cases where the outcome was not what was intended by the system, and we undergo a root cause analysis to understand why that happened and what specific changes we can make throughout the system to improve that. And the emergence of these collaborative efforts, I think, is a really important and positive step for our city, and we look forward to continuing to move that forward. Next
John,
slide,
can I
please.
ask you a quick question?
Sure.
I know one of the things you said was very poignant in that sometimes it's hard for criminal justice stakeholders to get feedback or to receive feedback and actually implement those policies because we believe that we know what's best. How have you worked with people to make sure that they take a fair look at their policies and determine whether or not are these policies having a negative impact or positive impact on our communities or the people that we are supposed to service?
Well, I think that what we try to do when we do our work is to evaluate what a policy is actually doing, again, on a group level and not necessarily case by case.
Sure.
There will always be opportunities to take an extreme case and use that to prove a larger point, and sometimes that's accurate, and sometimes it's an extreme case. In both situations, we want justice to be done all the time, but we try to generate data that allows people to look together and ask, well, why is the data this way? We may not agree on what the data says, but that will lead us to a next question about how do we better understand this data. And ultimately, once we understand what's really going on in the system, we can have a thoughtful conversation about how to change it. And so I think it's the opportunity to generate data, aggregate that data, and evaluate that data that is what leads to a consensus-driven reform, and therefore reforms that will actually be implemented and accepted by the community.
Do you use community in your analysis or in some of your research? Do you use their feedback and understanding of what the policies that we've now been practicing in our criminal justice center, how that has an impact on them, or so that we can be educated by them as well?
I think the more opportunities that we have for people who are actually participating in the system to share their experiences so that they can be understood, the better off we all are. And I think one of the things that we try to do regularly at the Quattrone Center is to host public meetings where people can come in and hear about things that are happening and share their stories. Because, and I think this is true also with the criminal justice professionals. I think it's very useful when you have defenders and prosecutors and police officers sitting down to look at a particular case, and the question is, well, why did you act like this? Why was this decision the one that you thought was the thing to do? And when the people who are on adversarial parts of the system reach a better understanding of why the other side is acting the way they are, it leads to a willingness then to work together to solve that problem that I think is sometimes hard to get when we're at loggerheads trying to figure out what the right thing is to do.
Thank you, John.
So, as the Chief Defender said in her introduction, I think there are really three things that we're going to try and do as the Quattrone Center in assisting with the important work of this committee. We hope that this committee will be able to promote public safety, which I think is an important thing to remember with the criminal justice system. So much of when we talk about criminal justice reform is about the injustices that happen to individuals. It's important to remember that a large part of our criminal justice system is devoted servants of the city and of public safety who have a very important job to keep our community safe, our property safe. And so promoting public safety, but doing so in ways that are fundamentally fair and fiscally responsible, is, I think, essential to the work of this committee. And it is our hope then that we will be able to participate in that and use data to both, if you could hit the next slide, that we could use data to study and learn from cases where the system doesn't give the result we want, use data to propose the removal of structural barriers to the truth. And what I mean by this is we don't know how many people plead guilty to things for which they're innocent because the burden of pre-trial detention is such that it makes more sense for them to plead guilty than it does to wait for their case to run through the system. So I would describe that as potentially a structural barrier to the truth, in that you have somebody who's pled guilty to a crime that they didn't commit, and we need to remove those structural barriers so that we're able to actually have the truth be driving the responses to justice, so that those responses actually do what we want accountability measures to do, which is reduce the recidivism and the recurrence of crime. And the other thing that we'll want to do is we'll want to talk about expanding the toolkit of options for accountability. The fact that the MacArthur Foundation gave out $20 million of grants to reduce mass incarceration is proof that we're realizing as a society that incarceration is a pretty blunt instrument to change people's behavior. And with diversion courts and a number of other progressive reforms that many of the people on at this table have helped in implementing in Philadelphia, we've begun to broaden our toolkit as far as approaches to individuals that will prevent them from committing the next crime, as opposed to simply incarcerating them. It's important both that we expand that toolkit and that we evaluate the changes that we're making to make sure that when we implement a proposed reform, it's having the desired effect and leading to the change we want, and that we maybe can optimize it and tweak it and improve it as we move forward. So what's that going to take? Well, I think it's going to take a lot of what you see here. It's going to take strong leadership throughout the city, focused on improving human and economic outcomes. It's going to take coordinated review from all of the stakeholders in the criminal justice system of existing policies, and those stakeholders have to be armed with rigorous and thoughtful evaluation of both the practical and economic impact of the changes that are proposed. And in order for that to happen, obviously, we have to have the continued and wonderful administrative support that this committee has had had so far. And so that's all that I have for right now. I'd be happy to answer any questions, Chief
Thanks,
Defender, or
John.
anything else you'd like.
You want to move through the discussion of our reform efforts, or do we want to take questions now or later?
I defer to the chair.
Okay. I would say if we can move through our discussion, some of your questions could be answered through the rest of the discussion, some of them, so we'll keep it flowing. But John, one of the things I heard you say, which I appreciate, is that data sharing is going to be really, really critical in this, and I think that we have a hard time sharing data and information about all respects of a person, from mental health treatment, from social service involvement, and of course, what people need when they come through the system and what happens to them afterwards. In order to do that, everyone has to be equipped with the data collection ability to share our understanding of what's going on and measure our impact.
I don't think there's any question about it. Data sharing is vital, and I think that can be done in ways that anonymize or de-identify data at the aggregate level, again, so that we can see what's happening at a system level without it jeopardizing the outcomes of any individual.
All right. Well, thank you. John has laid out the goals for our criminal justice system, and we want to talk about our work for reform in terms of those goals. The first goal, and the first piece of discussion or area of discussion to deal with the goals that we are looking towards will be discussed around the area of fiscal responsibility. Are we using taxpayer dollars wisely? And so I want to invite Kevin Bethel to discuss some of the programs that he has been involved in that go towards that goal of using our taxpayer dollars wisely, and explaining what the impact of those initiatives have been.
So I thank the Chief Defender, and I thank President City Council and my friend here, Councilman, for the opportunity to be here. So I purposely didn't write down any notes because I wanted to really speak from my heart about how this process really can work. And John, you really set it up. So I may feel like a CEO Inc. today just because of what we've been able to do. And so I appreciate your comments because you really set it up very well. And so I'll jump right into a process. And first and foremost, let me acknowledge two good friends of mine. I'm going to talk about a program that the City of Philadelphia Police Department is now engaged in for the purpose of introduction. You heard I'm retired Deputy Commissioner Kevin Bethel from the Philadelphia Police Department, retired after 29 years, and moved into the Stoneleaf Fellows as a Stoneleaf Fellow. I'm working at Drexel University in the Juvenile Research and Reform Lab, and I'm here to tell you I'm not an expert. I'm not an expert in juvenile. I'm a cop after 29 years, realized that we had to do something different. And also blessed to have two phenomenal individuals to work for, Commissioner Ramsey in his charge, and now my good friend and guy I have so much respect for, Commissioner Ross, who's allowed me to continue on in working on a program that I think is going to change the way we deal with young people across the city of Philadelphia. And so I definitely want to acknowledge those two men as very, very strong influences on what is happening and what I'm about to talk about. In May of 2014, I took over as a patrol operation in the schools and had the school force, and had done some traveling, and met a lot of individuals, and started to look at data. And my good friend down here, First Assistant George Mosey, who's been a mentor for me for almost 2 decades, came and said, listen, I want to do something with how young people were being arrested in our schools. We have 1,600 kids are being arrested in our schools every year at the minimum age of 10 years of age. And I remember going back and forth with my friend, and he said, Kev, listen, you do what you have to do. Diversion and those types of things are yours to do. And so that started down this process of building a very strong collaboration. We can make change in our systems. I looked at the arrests. So here's an example. A 10-year-old child would walk into the school district who may have taken a pair of scissors to school because they wanted to finish a project, walk through a metal detector, and that metal detector would go off. That metal detector would require the school officer to call the police. Police officer would respond, take that child from the school, have him or her fingerprinted, photographed, often held in a cell block for 6 hours, and then released. The youth aid panel and the DA's office had a great post-diversion program, which George has been a head of for many years, where they would divert that young person back out into the community. There they would be given some sanctions under the youth aid panel, given supports if they needed it, and if they stayed out of trouble for 6 months, they would have their record expunged. And I challenged that process. I said, a 10-year-old child, we weren't asking these kids what was happening with them. We did not ask them whether there was any sexual abuse, physical abuse, and what the conditions of their homes were. And what was that trauma? What were we doing to a child when we took them into our custody and put them through that process? And so, I'm blessed that the police department and under Commissioner Ross now said, you know what, we're going to push back against that. And can we do a pre-arrest process? And so working with certain departments, and I'll highlight them right now. Department of Human Services, I cannot speak but volumes of love and respect for the work that they're doing. Because I came back to the group, I'm part of a Juvenile Detention Alternative Initiative, a DMC subgroup, which George is a part of. And I challenged the group and said, listen, I want to do a pre-arrest diversion. I don't want to put a child through that process. Because all the data says is once I bring him or her into that system, they're going to recidivate. If I don't bring them into the system and I get service to them ahead of time, could we stop that flow of kids coming back? DHS stepped up and offered 6 programs across the city. They're positioned in various areas of the city. And so we take that scenario now that I talk about, where we had that child, a 10-year-old child who's fought in the classroom, who's being arrested. The Philadelphia police officers, so let me take a moment for that. I know Commissioner Ross spoke at the hearings, the budgetary hearings the other day, about oftentimes police officers not given the credit for the good things they're doing. I'm sitting here to tell you today that the Philadelphia police officers out there want to do their work and do it effectively. But they have to be given the tools to be given other options besides bringing a pair of handcuffs to a situation. And so what we were able to do was bring a different dynamic by saying, hey, we're going to take that same kid and be able to provide them with services. So when that Philadelphia police officer goes to the school now, there are 84 school officers who respond to the schools and make those arrests. They don't. For any child who is first-time offender, who's never been arrested before, who's not in the system, and the majority of our kids are not in the system, the officer does not take that child out of the school anymore. He gives that child a letter that says within 72 hours, DHS social workers, along with police officers, often cases, go to the house, and ladies and gentlemen, they do a home assessment. They go into the home with the purpose of not taking that child out of the home, but what are the things they can offer to that family that they need? And DHS is turning on gas, turning on their electric, offering bedding, getting other services to family members in that house. Those are the things that are going to be the change agent, both for the DHS, but more importantly for the police department, to be looking at that kid in a different way. After that assessment is done, those kids move into the program, and they will stay in the program for 30, 60, 90 days. In some cases, they can be extended, where they're working with those kids to get them back on track. And I'm here to tell you that those young people, and I call them my kids now, are doing a phenomenal job of going through the system. Now here's the thing. People get upset because if I gave you that matrix, I didn't tell you about a stick. There is no compulsion in a stick. So we give those families an opportunity to get the services that they need, and they get a choice in the matter. They're not forced or compelled, but 90% of those parents are taking part in those services because for a long time, if I locked up a kid, I can get wrap around, wrap over, wrap under, any kind of services I want. But there was no services out there when I wanted to go in a proactive stage. And so it has been a blessing to be able to work because Karen Lynch is walking back into the room now, and I was kind of talking as she do. But the school district I started this program with Dr. Height and met with Karen early in the process, and they were 100% on board. I work with the Defenders Association on this program because they're one of the greatest advocates for the program, the District Attorney's Office. And then I'm assigned to Drexel University. I was fortunate to get a grant, a $600,000 grant, working with Jocelyn Arnold and the city government and the grants department to come on board to do the evaluation of the program. Because now we're talking about, as John talked about, a data-informed, evidence-based approach. Is the process working? And one thing, having a formidable organization and a formidable institution to come in to do that data set now helps to inform the whole process.
Kevin, can I ask you a
Yes,
question?
ma'am.
I'm sorry to stop you.
I know I'm running long.
What you just described is a real smart on crime initiative, obviously. But is there a way that we can rebalance the police responsibilities and put more into the schools or any kind of professional workers to identify the things that the police are identifying so that there is no need for real police contact for the type of kid you're describing that goes through these programs?
Listen, I know that Karen could probably tell the services that the school district needs. I was in Atlanta, and man, they had social workers and counselors and psychologists in all their schools. And so we know what the schools need. I mean, our goal and the policing goal before I left was to try to just fill that gap. And so I know, we know the services that are needed. We know that we're identifying these kids and the level of services they need they come from these impoverished communities. They need those services. And one of the things that Chief Defender, which is really unique, is that we did an assessment of the first 800 kids that we brought through the system so far. We've had a total of over 900 kids that were diverted and not arrested. And only 36 of that first 800 kids have come back.
Nice.
And we started the program in May of 2014. For anybody who understands the level of recidivism, to have a 4.5% recidivism rate over 2 years is an amazing and staggering number. When we know that it goes into 20 and 30% when a kid goes into custody, that we believe we're on the right track because the kids are not coming back. And I see my friend Ted from PAL, halfway through the program, we introduced those families to the PAL centers so that on the 91st day, if a parent has something they need to do with a child, they can take them to our PAL centers. But we know what's needed. I mean, we're seeing that every day when we go into these homes. The conditions we're seeing in these homes are terrible. My cops report back the conditions are just terrible. And so, if we don't start to look at this process and start to move those supports up to the front end, then clearly we understand what we're going to get on the back end.
Right.
And so I don't know if I'm answering your question, Chief Defender, but we know that the school district needs help with those types of services. And until we do that, we're going to constantly be spinning our wheels, and we need to direct our money in those areas on the preventive side to help with that issue.
Yeah, this seems like a program that's working well, and not just in terms of recidivism, but in terms of long-term stability. And it would be great if we see some of that responsibility shifted to the schools so they can deal with it in the appropriate setting where the kid feels extremely comfortable. But also, the police department, in engaging in this, has extended its services to what I would say is more social work involved as well.
Well, I mean, it is the reality. You talk about smart policing, smart on crime. I mean, when I look at the data, it is the smartest thing we could do is to divert a child before he goes into that crazy system that you've been seeing described by you and described by John. Mm-hmm. I mean, we're sending them into a place that they never can get out. And so I think anytime we can create tools that move that up front, particularly, we're talking about low-hanging fences. We're talking about locking up kids for disorderly conduct. Listen, I'm born and raised in the city of Philadelphia. I never thought that any cop would come in and I would have to be arrested for fighting with my buddy in the hallway, or to come into school with a pair of scissors. I have a daughter who goes to parochial school. She got the long scissors, short scissors. She got all kinds of scissors. I have a daughter who goes to Central, and she ran back to the car the other day because she had a spoon in her pocket because she was scared the metal detector was going to go off. And not that that would be an offense, but just the fact that she felt that way. And so we need to be realistic about the policies and the procedures that we are in. This is a stopgap. The goal is to put ourselves out of business. We went from 1,600 arrests the first year and dropped 54% to just a little over 700. This year, we're on pace to potentially have less than 400 kids in the school district arrested for school-based offenses for a system that was doing 1,600. Almost a 70-something% reduction in the number of kids coming into the system. We can change this system when the right people, as I look to my left and to my right and behind me, stand up and say we want to change the system. We can make those changes, and we just have to put our boots on the ground and make that happen. But when you can see such a reduction in the number of kids being arrested, and we can also translate that to other things across the city as it relates to diversion. And so I dovetail into the fact, before I left, I worked on the MacArthur Project, as you know, again, a smart crime initiative to looking at diverting those first-time drug offenders, to see if we can move and direct them into services versus having them into custody, because putting them into custody is not going to help them with their addiction issues. And so I look forward for the opportunity as the police department, and I see Julie just arrived, and Judge Lerner, to talk about what MacArthur is going to be doing. And fortunately, just recently with Drexel University, may be able to come on along with other agencies to provide the support to really evaluate that, as John said, to evaluate whether that process can work.
Thank you, Kevin. And I guess what you're saying rings true. Less in means less burdening of our system and our resources, and of course, the more wisely we use our tax dollars for long-term effect would be great. And I do want to talk about that from the standpoint, not just pre-arrest diversion, but also once you get into the system and you go through the process of, as I described earlier, and you come to the end, and now you're charged with being on probation or whatever that, whatever sanction that you're on. There are ways in that system, in that process right now, that we are looking towards reform efforts as to how we deal with human mishap. I mean, there's people that come out on probation that have had a long history of addiction, and sometimes they are going to slide are going to backslide or kind of, have some hiccups along the way. How we deal with this as a system, could you speak to that? I'm sorry, I'm butchering your name. Mr. Parole, the state parole agent.
That name is Rich Pujeski.
Pujeski, that's
Right.
right.
It's a long Polish name. I'm a Reading kid, so. Well, yeah, let's talk about violations of probation and parole and how we deal with those violations of probation and parole. One of my mentors many years ago when I got started in this business gave me a quote, and it goes something like this. When dealing with probation and parole violations, give the offender what they need, not what you think they may deserve. And I think that is one of the driving forces that has driven my thinking in terms of responses to violations of probation and parole. Around the country, you're seeing things like this. I just want to read a few lines to you about how other states are dealing with violations of parole. The goal is to implement strategies for supervision that result in an increase in the number of offenders who complete parole as stable, productive, law-abiding citizens. That's Georgia. Kansas. Our system helps offenders be successful and does not create new victims. In New Jersey, the violations process and our work of our policy team should enhance the ability of offenders to transition successfully from prison to the community. And I can tell you that Pennsylvania takes the same approach in our response to violations of probation and parole. But how do you do that? And how do you do that? Violations and responses to violations need to strike a balance between holding offenders accountable for their behaviors while at the same time providing opportunity to correct or sanction that behavior in a progressive, proportional, and graduated fashion. Now, that said, how do you do that? How do you find that balance? And at parole, we provide public safety, and we provide it by balancing risk management and risk reduction. Strategies that have been proven to manage the risk and strategies that have been proven to reduce the risk, thus making our community safer. So when you think about violations and you think about responses to violations, you have to consider two things. You have to consider the risk of the person. Now when I say risk, that's a scientific statement. It's not an emotional one. What is the person's risk to commit future crime? What is their risk to recidivate in a community? You have to consider that. You also have to consider the seriousness and, in some instances, the frequency of the violative behavior that is being displayed. So you have to consider those two things when you respond to a parole violation. Now, there are some violations, some behaviors that warrant going back behind the wall, such as assaultive behavior, such as acts of violence. But the greater majority of violative behaviors can be dealt with in the community through interventions. Now, the city of Philadelphia has a whole lot of community interventions that are available. And let's face it, the city of Philadelphia probably has more community interventions available to state parole agents than in some other areas of the state, which we're very thankful for. But you need those community interventions as options for parole agents to consider and district directors to consider when they have a person in front of them who has violated parole in some way, in a technical way, and they're trying to figure out how to respond to that. Now we at the State Parole Board have a nice little tool that we use that helps guide us in our thinking when it comes to our responses to violations of parole. And it's called the Violation Response Grid. And it's been around for several years. It builds on the good work of a person named Peggy Burke from the Center of Effective Public Policy. And it builds on a lot of her work in responding to parole violations. And essentially what it does is it accounts for those things. It accounts for the offender's risk. It looks at the seriousness of the violation and ranks that violation in terms of low, medium, and high. And the violations range from everything from a travel violation to a failure to report to a changing address without permission, all the way up to including the arrest for new criminal charges and possession of weapons or firearms and ammunition. So it runs the entire gamut of violated behavior and ranks the violated behavior.
Rich, can I ask you
Sure.
about that? Basically, when we're talking about promoting fiscal responsibility, we understand some of the kind of things that you have to consider, but also there's a line of thought that in looking at probation's responses, how are we dealing with issues of relapse or kind of stumbling blocks along the road in real time versus bringing people back through the system where that drives the cost
Right.
analysis. And it kind of sets, we hear a lot, it may set people back a bit
Yeah.
to be sitting in jail for a period of time just to develop new strategies on how to help them work through their probationary stipulations.
Yeah, issues of relapse are dealt with through treatment. I can tell you that at our agency, individuals who relapse are afforded an opportunity at treatment. And that's frankly the right thing to do, considering their risk and that nature of the violation.
Do they come back through the prison system and through the court system in order to deal with treatment?
The treatment is generally provided within the community. Yeah,
So probation officers address them right in the community in real time
That's right.
versus bringing them back through the
That's
system.
right.
And that is a fiscal responsible
That's right.
initiative and program, because normally, generally, the way it went is that if a person violated, they would have to come back through the system's process, and then we deal with it by going before a judge and
Right.
explaining what happened.
right. For the probation system, that would have to come back in front of the judge. For the parole system, we deal with it within our own district offices.
That's
So
good.
we have the entire gamut of sanctions available to us, whether that's treatment, whether that's a halfway back situation where a person's placed in a community correction center, or whether that person is placed behind a wall. But the drivers of that are the risk and the nature of the violation. And that's an important distinction. Oh, sure. And that's an important distinction. So what we do is we look at the violations and we rank them. And then we look at the responses that a parole agent or someone can place upon an individual in response to the violations, in response to the violated behavior. And like I said, they're imposed in a graduated, progressive way. So we look at the person who's in front of us in sort of a holistic sort of way prior to giving out sanctions in response to the violated behaviors. We also are governed by Act 122, which is the enabling legislation, Act 122 of 2012, which is the enabling legislation of justice reinvestment. And what Act 122 did was it provided us with additional guidance in how we should be dealing with violations of parole of a technical nature. And it provides us some guidance in terms of the type of offender that can be reincarcerated behind a wall. And we call them the Fab Five. There are 5 instances of violation where a person can be placed in what I'll call a community or a county jail situation or a period of an incarcerated state. And those Fab Fives are if the technical violation is sexual in nature, it is assaultive behavior, it involves possession of a weapon or control of a weapon. That person is an absconder who cannot be otherwise safely diverted, or if that person represents an identifiable threat to the community. So like I said, if a technical parole violator exhibits violations of any of those 5 types of violations, well then we're enabled to place that person in a state of incarceration. Short of that, we have our sanctions that I just spoke about in response to other violations of a technical nature where we can respond. But we've also gotten, as a result of the act, secured community correction centers, violation centers in some states they're called, where a person is placed for a period of 6 months or up to 6 months for a first violation of parole, up to 9 months for a second violation, and up to 12 months for subsequent violations of parole, where a person is placed at these centers where they'll receive treatment and other interventions that address the violative behavior that placed them there to begin with.
Thank you.
So it came a long way for us, the Act 122.
And Rich, I would, we have about 2 minutes left for your presentation.
2
I'm
minutes
sorry,
left
just so
is
we can
fine.
get to everyone. But in terms of what you just said, the
Yeah.
economic impact of that, do you have that? Because this is one of the areas of reform and goals that we're working towards. How can we be more fiscally responsible and have a better impact?
Yeah, I think in a closing statement, I think I can answer that question. And I wrote this down, and this is another one of the phrases that a mentor of mine would oftentimes say, that if you can safely manage the person who is under community supervision in the community, well, then manage that person in the community. And I think that goes a long way in terms of thinking about who should be placed back behind a wall and who should be provided community intervention if appropriate, considering their risk and need. So.
Thank you so much. And I guess we all know that the cost of incarceration are pretty costly, but they won't get as robust of an intervention strategy as they would in the community, which are better, more effective uses of tax dollars.
Without a doubt.
Thank you. Next, we will talk to Mr. Mark Holden, who is the Policy Director for the Defender Association of Philadelphia, talking about our goal to be a more fiscally responsible system. How does the initiatives that we're embarking on, especially through MacArthur, help advance that notion? And I would ask if we can keep our comments to 10 minutes so that we can get to everyone in the, on the panel, please.
Sure. I'll keep it under 10 minutes. Thank you, Keir, and thank you, Council President Clark and Councilman Jones, for having this hearing and for inviting me. I want to talk briefly about first appearance. It is the point where bail is set by a bail magistrate within 24 hours of an arrest. That's a critical time both for the system and for the individual. So as Dean Holloway mentioned, from a systems perspective, it is when the system begins to work. It's the first time that a judge is together with attorneys from both sides, the district attorney and the defender, with an individual who's brought in by the police. And there are ripple effects to decisions that are made at pretrial hearings. If someone is detained, they are more likely to later be convicted. If they are detained, they're more likely to recidivate when they get out. So what happens at that first hearing is critically important to what will happen later throughout the process. The purpose of bail is the presumption of release, along with the least restrictive conditions, to ensure that an individual comes to court and that the public remains safe. I think it's important to note that bail was not designed to keep people in jail that are simply accused of a crime, but rather to give a way for individuals to remain free until their trial. And I think while it was supposed to be the exception, pretrial incarceration has become more of the rule. And I think we need to work to flip that back to the way it was designed. Two things that are looked at is risk of flight and dangerousness to the community. Now, in terms of flight, I'll just say briefly that many of the offenses that we see in Philadelphia We're not dealing necessarily with highly sophisticated crime rings and an individual who has their passport and tickets waiting at home. You're dealing with someone who lives in Philadelphia, whose family's in Philadelphia, and this is where they're going to stay. They're not trying to leave the city, they're simply trying to be at home while they wait for their trial. And we know that most people released without bail in Philadelphia do return for their court date. And there are other steps that we're going to begin to take to help people remember their court dates, because unfortunately that is a common reason that people miss court. And there's also the dangerousness component, which my colleague to the left talked about risk. Pretrial services is going to really catapult us into the 21st century with more sophisticated, data-driven approaches to determining someone's risk, as opposed to simply what their lead charge is, because the lead charge they're accused of doesn't tell us very much about the conduct or about the person. I'd just like to note that in Philadelphia, 60% of our jail population is awaiting trial. So that's 60% that are presumed innocent and are sitting in jail while their presumption of innocence is intact. And the average length of stay is 95 days. That's 4 times the national average.
Mark, can I ask you,
Yes.
what would be the economic and social cost of that, what you just described?
Absolutely. So there's the clear economic cost of housing an individual, which can be $35,000 to $40,000 a year. There are lost wages for that individual, lost tax dollars. The impact on the family as well, and getting into social costs, we start to deal with, like I mentioned, loss of employment, loss of housing, and also individuals with serious mental illnesses that come into our jails with public benefits that they need. If they sit in our jails for more than 30 days, they lose those benefits. And so when they're released, they are going to be in a worse position than when they first came in. And so that can create more economic costs and social costs than if someone were properly supervising the community.
How is our work and your work, especially as the policy analyst at the Defender Association, helping to bring forth information about that's pertinent for the decision maker to say whether or not someone will that economic and social impact will have an adverse effect on the community and the person, and weigh those balances for public safety?
Right. So that's a great question. And so currently there is a representative from the Defender's Office at preliminary arraignments, but there's no opportunity to speak with that lawyer. So that lawyer has no information about you and isn't able to effectively advocate. And so we're going to try to change that through funding from the MacArthur Foundation to have individuals interviewed before they have their preliminary arraignment hearing, to ensure that we know about the individual, whether they have a job, whether they have housing that's relying on them, whether they have children that need them at home, and really get a more accurate picture of what the individual circumstances and the individual costs could be of pretrial incarceration, and helping the court understand for individuals where release might be appropriate, why it would be appropriate, and why the public could remain safe. Without a lawyer at those stages, it's very difficult to gather that sort of information. And research has shown us, in Baltimore, they did an early representation project, and it was determined that nonviolent offenders were 2.5 times more likely to be released when they had representation, 34% versus 13%. Those that did go to jail that were represented stayed far less, a far less amount of time than those who were not. Those represented stayed 2 days instead of 9. So we have a lot of work to do to get down to that low of a number, but you can see the impact that council had, and they're 2 times as likely to be released the very same day they were brought in by police. That's important because after the 24-hour hearing, if you're not able to make bail immediately, you then get transferred to CFCF, and it takes longer to be processed and then longer to possibly gain your release. And lastly, I think it's important to note that when there is counsel, defendants in Baltimore felt that they were treated more fairly by the system. That's an important point that I think will be talked about later, but the perceptions of fairness is really important to whether or not an individual follows the conditions of their release. So they found that individuals who were represented were more likely to come to court and were more likely to abide by the conditions of release. So what we're talking about is trying to even the scales a bit and provide more information at this initial hearing that can help the courts make better decisions.
Thank you, Mark. And also go to our goal to be a more fiscally responsible system by using this model of representation that will bring about more social change and economic change that we need. I'm going to move to our second goal of our criminal justice system, and that is, does our system promote fairness? And I think Mary Catherine Roper from the ACLU is coming up to join the discussion of that panel discussion. But we'll start with this. When we're talking about does our system promote fairness, we want to make sure how we look at how do we address racial and economic disparities in the justice system. We all know the justice system has its largest impact on minority communities and also low-income communities. And so how do we address those things? As John Holloway stated before, how do we address two individuals that have two different profiles that commit the same offense? I think we're seeing all around the country the difference of the way we're treating heroin users and the way we've treated crack users in the past. And we're seeing two different mindsets come about as to how they should go in this system. One now is arguing that it's a public health issue, and one before was arguing that it's a criminality and public safety issue. So these things have to intersect in some real thoughtful discussions. And so I would ask Honorable Judge Lerner to talk about some of the procedural justice reforms that we are going to undertake, especially through this MacArthur initiative.
Thank you. My name is Ben Lerner. I am presently the Deputy Managing Director for Criminal Justice for the City of Philadelphia. That's a job that I've held for less than a month, and I won't be talking too much about that job because, frankly, I'm still learning what it's all about. So I'm completely the new kid on the block as far as this position. But I think it's fair to say I'm not the new kid on the block when it comes to Philadelphia's criminal justice system. I've been involved at various levels in that system for over 40 years of my career, 15 years as Chief Defender of Philadelphia, and almost 20 years as a judge on the Court of Common Pleas, all of which was spent in the criminal trial division. The first thing that I want to say by way of introduction, if you'll permit me, Keir, is that one thing I will say in connection with my new job. I personally am delighted to be invited to participate in this session here today because I think it's extremely important for this community that our efforts at criminal justice improvement and reform are collaborative. And by collaborative, I mean the administration, city council, the rest of the criminal justice community, and the general community. If we're not pulling in the same direction, eventually our efforts are going to be a lot less successful. And a perfect example of that collaboration and what it can accomplish was announced the day before yesterday when Mayor Kenney announced that the city had been chosen by the MacArthur Foundation to receive $3.5 million over the next 2 years in grant funding on the basis of a grant application designed by officials from every corner of the criminal justice system working together to come up with a plan to address many of the problems that you've heard the other speakers talking about. Problems of insufficient diversion, problems of an over-reliance on money bail that keeps poor people, and in this community, persons of color, in custody awaiting trial at a very inappropriately high and disparate rate. All of those things are going to be addressed, hopefully, successfully, by a continuation of the collaborative efforts of the people involved in this grant. But it's also extremely important, at least on the basis of my experience, I would say, it's extremely important for council to be effectively involved in this process, because council is the system's major link to the community. And ultimately, when we start implementing these practices that are described in the grant application, we are going to need the community's understanding and the community's support if we're going to be successful in doing this. And we won't have that support because we won't have that understanding without the active engagement of this council. So I also want to thank Council President Clark and Councilman Jones and his colleagues because we need you to make this work. You've heard a lot about bail hearings. You've heard a lot about violation of probation and parole hearings. You may have heard something before I got here about trials. I've had some experience in all of those areas. I understand the importance to individuals charged with crime of fair and dispassionate judicial proceedings. And I think that I understand the responsibility ultimately falls on the presiding judge, on our trial judges, both at the municipal court and the common pleas court level, in the family court division for juveniles, in the criminal trial division across the street, to ensure that proceedings are fair, that they are prompt, and that the decision-making is unbiased. We know as individuals, at least if we are honest with ourselves, that whatever our small p political leanings are, whatever our philosophies are in terms of human rights, civil rights, the balance between public safety and offender treatment and rehabilitation, we can be the most liberal people in the world. We can have been raised in the most liberal families in the world. But we're human beings, and all of us have implicit prejudices and implicit biases. The court throughout Pennsylvania recognized that several years ago when the Pennsylvania Supreme Court formed an ongoing standing committee on racial and gender bias and fairness. Out of that has come several concrete efforts, including implicit bias training mandatory for judges, to get us as individuals more sensitized to these issues of gender and racial bias and prejudice. Having attended one of those sessions personally, I can tell you that no matter how fair and liberal you think you are, you learn something and your thought processes. And when you learn something about that, you're in a position to do something about that. That's, I think, job one for the courts. Job two is to make sure that we have prompt, fair hearings, that we have effective representation for people who can't afford their own representation, which means in Philadelphia, almost 3/4 of the defendants who appear in our criminal court system. I want to give an example of that. I want to pick up from some things that the gentleman from the Probation and Parole Board said. When you are a judge and you have people on your probation, it's up to you in our system. I don't care what the rules say or what the procedures are. It's up to you as an individual judge to send a clear message to the state and First Judicial District probation and parole officials as to how carefully you want to monitor people who are on your probation, or in the county system also people who are on your parole. If you let them know that you want to be kept advised as to even technical alleged violations of your probation and parole, and that basically there's no alleged violation that's too trivial for you to be informed of, they will do that. If you don't, they won't. If you are a judge and you let the probation and parole officials know that, generally speaking, except in very, very specific categories, you want to decide what the consequences should be for a probation violator, or again on the county level, a parole or a probation violator. And you want to do that not simply on the basis of an exchange of emails between the department and you, but rather you want to do that in an open hearing in court with the defendant present, represented by counsel who's notified in advance of the allegations of violation and prepared to address them. They're going to do that. And if you don't, in many cases, they won't. That's just a specific example in a certain type of proceeding that I think demonstrates how the court system can and should demonstrate the required level of fairness and impartiality before making a decision. Commitments should not be automatic, except in cases where a defendant on probation and parole is charged with a new, serious, generally violent offense. Commitments under those circumstances ought to be because of the conscious, thoughtful decision of a judge after the judge has heard both sides. And even in those cases where commitments are automatic, where what's called an automatic detainer is lodged, it's the judge's responsibility to hold a prompt hearing if requested to see whether or not that detainer should remain, or whether or not it's fairer, more appropriate to release that defendant under whatever strictures are necessary to ensure his or her appearance until the open case is disposed of.
Thank you, Judge. I want to give the other panel members an opportunity to speak towards this, but if...
I'm done.
Are you done? Okay.
I'm done.
I didn't want to say anything to the former chief defender, just in case, give me any advice. not being biased, but in talking about bias, I'm glad you mentioned something that's really fundamental to recognizing our own bias. Sometimes what we see is not a result of intentional acts, but unintentional tendencies for us to view a person in a certain way. Now, while there are some unintentional tendencies in our system that create this disparity, we still have to look at the fact that there is this disparity. And how do we deal with that? I keep coming back to the fact that we're looking at the different ways of dealing with drug users based on the profile of people who are coming in. And how do we get that same fairness or that same standard or level of compassion for everyone? I know, Mary Catherine Roper, you do a lot of work dealing with civil liberties for all. And what kind of initiatives have you seen that have gone to understanding the impact our system has on one community versus another? And can you explain to us what we need to do to kind of deal with some of the challenges we have?
Sure. So, speaking from the perspective of an outside advocate, someone outside from of the system, we, whether it's the ACLU, CLS, other organizations, we generally have no more information than, you need me to get closer? I can do that. Than the general public. We hear from the general public, and we collect complaints, and we keep them in our own database, and we look at what issues are being brought to us. But those really are just anecdotes, and it has often been said the plural of anecdote is not data. Data is a different thing. Data is a deliberate effort to look at an issue and measure an issue, because what you do not measure, you cannot improve. You don't know whether you're improving. We know that many policies in the criminal justice system impact, well, in fact, all of them impact communities of color. Many of them impact communities of color disproportionately. And many of them have impacts that are not only more frequent, but more severe in communities of color, because people may be more economically vulnerable. So we heard about pretrial detention. That affects everyone, but it affects poor people more. And you will see that effect much more, of course, in communities of color, where we have higher rates of poverty and more economic vulnerability, so that even if you're not in poverty, even if you have a job, but then you spend your 90 days in jail waiting for your trial, you no longer have a job. You may no longer have an apartment or custody of your children as well. None of these policies are aimed at impoverishing communities of color. That's just an effect. But it's an effect that we have to measure, and we have to then take responsibility for. So I will just talk about the area of policing, because that is something that we have a great deal to do with. What our experience is that you need several things to address impacts on community of color. You need to acknowledge those issues, and Keir was talking about some of the issues of implicit bias, when people are not intending to behave any differently toward people of a different race or people of a different background, but they end up doing so. That is one of those things that you can, and I know the police department has engaged in training to try to address, but you do not know if that's effective unless you collect data and you look at data. So we have the example of stop and frisk. Our Philadelphia police officers have been filling out a form every time they stop somebody since the mid-90s. And it used to be that there was a position within the police department, an integrity and accountability officer, who would look at that data and generate reports and say, here's an effect you may not have been you wouldn't have necessarily paid attention to. Here are racially disproportionate effects of policies that we believe are racially neutral, and maybe we need to look at those effects. Unfortunately, after some years, that position became vacant and ultimately was abandoned. And as a result, what you have then is, someone like the ACLU coming along later and saying, hey, we can look at the data too, and now we're going to file a lawsuit rather than having this addressed sort of internally. It is much better, of course, to not only have the data, but internally use it and be responsible for it and take responsibility for it. An example, again, just from the world of stop and frisk here. We know that the police department had these reports for many, many years, but it wasn't anybody's job to look at them. Ultimately, after the litigation began, it became the inspector's jobs to look at them and generate reports on them, but it still wasn't anybody's job to do something with that information and those reports. Commissioner Ross now has made it his job to do something about those reports, and has instituted a new system of sort of top-down responsibility for what those reports show and what that data shows. That is an example of the kind of leadership that is frankly the only thing that is going to move the needle on policies that have disproportionate effects on communities that are vulnerable. We need the data, yes, and it can be helpful to have an outside agency like the ACLU, like any public accountability body or any member of the public looking at that data, but all we can do is identify the problem. Ultimately, what is going to be needed is a systematic collection, analysis, and then responsibility, taking responsibility within each department. Essentially, Commissioner Ross is the Integrity and Accountability Officer for the Philadelphia Police Department, and that is a role that someone needs to take responsibility for. Judge Lerner talked about it being the responsibility of the president judge to ensure fairness in the court system. The buck has to stop somewhere. And so in talking about all these efforts to improve, virtually all of them, of course, are initiated by what we find in the data. And sometimes we have an opportunity, such as the MacArthur Grant, to really sort of take a bold step to make a change. But I would suggest that the value of this committee is to look where we can find places, even without the wonderfulness of a MacArthur Grant, to decide where the buck's going to stop, to find out where in our internal structures we're going to take responsibility for the effects that we can see. And I will say that, frankly, there's a great role that the public can play. But the public can't play that role without access to the information and access to the data. So I guess my sort of pitch here is twofold. To empower our accountability partners, some of whom are outside the city or outside the government, whether it's the public or organizations like the ACLU, other sort of watchdog accountability organizations. But the other then is rather than playing defense, what this initiative, right, and this whole program gives us an opportunity to do is to find places within the system where someone's going to say, okay, I'm going to be responsible for looking at that information and deciding what the next step is to deal with it. In some cases, we have all the tools we need, we have all the data we need. In some cases, we don't. This is a multi-pronged effort, but it's got to involve both collecting the information, analyzing the information, and then taking responsibility for the information. And I think that is really the whole purpose behind this step and this committee. Your outside accountability partners stand ready to help you with that, and hopefully help you shy of litigation. We'd rather avoid that sort of thing as well. It is a marvelous opportunity, and we know how it works. And ultimately, what it takes is the commitment that we see and have seen in a number of areas, and we just need to spread that around.
Thank you, Mary Catherine. I think you're right on the money with respect to the impact and looking at the data and having an independent committee come up with some kind of recommendations on what we do, what's practical, and make more creative solutions available to us when we're looking at, I think some of the things that go into that are there areas where there's kind of police saturation? And if there are, does that create more of an opportunity for low-income residents or people of color to be stopped and be contacted by law enforcement? So some of those things that we have to look at, it's really kind of an effect of what's going on in the communities, but also it's having an impact that can be detrimental to many. Lastly, we're going to move to our third goal, which is how does our system promote public safety? Of course, we all, no matter what hat we wear, want to be safe in our communities, and this is a prime goal of our system. One of the things that we talk about often with public safety is wondering, are we catching the people that are causing the most terror in our communities? But public safety opportunities also work when we are looking at the people we are bringing in and helping to make them more effective citizens when they come out, giving them the resources that they need, making sure we understand who they are, and not making them more desperate. So community safety and public safety has so many different layers, but I would like to ask Councilman Curtis Jones to talk about the work that he has done and the information that he has gathered in looking at different ways to promote public safety through helping individuals who come through the system.
I just want to say, Madam Chair was an excellent selection. She is moving us through this process in an effective way, and I just want to, for the record, say thank you.
Thank you.
You second that? You want to keep her in that position. So, yeah, that is.
That's why he wants to say that.
You got me. I just wanted to also say that as a council member and chair of public safety, my colleague and I, Councilman Kenyatta Johnson, share this passion on council. And it is our intention to take what we learn here and apply it to the budget process. So everything that we say, do, and recommend should be at least in a problem statement, a suggested solution, and a way to plug it into what exists or create what is necessary. I think one of the things I noticed when President Obama sneezes, the United States of America catches a cold. But in the case of justice reform, when he starts to evaluate the process and problems associated with criminal justice, here locally we catch on. And I think that's an important statement of time on where we are with an opportunity before us to really, really make an impact. That is not to say that people who have come before us have not done a good job of doing this. Whether you talk about CJAB or PCCD at the state level, they've paved the way for this. But we are in this chamber are now paying attention. I've heard most of you testify before, sitting in those tables right over there, and I actually listened. But I won't say that we, balancing our city's priorities, didn't take this as the premier thing to do at the time. I can assure you, because of President Obama and what President Clark has prioritized, we are now. We are listening, paying attention, and are going to do what we need to do to make this successful. So, Right now, as we speak, approximately 7,500 men and women are sitting on State Road in overcrowded conditions. It prompted a debate in these chambers about whether we should proceed to build a $500 million new city institution to house them, or to start to discuss alternatives to incarceration that we find ourselves discussing today. We realized that 80% of them were waiting a trial, many of them there because they could not afford bail, being punished in effect because they are poor. Many of these inmates would be free because of their nonviolent nature of their offense, and if we had alternatives to incarceration and alternatives to our bail sentencing structure. This is not just a local issue. It is a national issue and of national concern. It is a moral imperative, but it is also an economic priority. Because at this point, we realize that 1/3 of the city's budget goes to public safety. So we're not cutting costs if we're not attacking this problem in a meaningful way. It costs approximately, and I've heard different figures depending on your cost accounting system, $120 a day to incarcerate. Roughly about $126 million annually to take care of State Road individuals. It's approximately, on average, a 6-month waiting period. 6 months waiting period. So if that, I went to public school, but if you do the math, at $34,000 a year, I believe that's close to University of Penn tuition costs. You could probably send some of these young men and women to an Ivy League school. And whether you are as my colleague, one of my colleagues accused me of being a hug-a-thug kind of guy, or one of more Tea Party conservatives, it's something we both can agree on. Because if you want to save a soul, there are alternatives to incarceration to do it. If you don't care about the soul, you care about your wallet, there are ways to contain costs through these alternatives to incarceration. So whether you're from a red state or a blue state, we can agree on the state and condition of justice. And there's a better way, a fiscally sound way to approach it. And I'm not under the illusion that some individuals do not belong incarcerated. The Daily News chronicled one of my childhood friends that I had, and it was almost a neighborhood party when he went away to prison because he was a menace to our community, and we knew it. And crime rate went down in Winfield, maybe 40% because he went away. But there are individuals who do not deserve that fate. So we want to be driven by facts and not fear, and we're going to apply them to our budget process of this year. So 2 examples of what we might consider as a result of some of our research is the Red Hook example out of Brooklyn, New York, where they have a justice center in Red Hook community in New York, where they actually have made a priority of the community what crimes they believe should be given particular attention. And they address that priority annually. What they also went and did was applied a one-judge, one-case management system, which takes an individual through that process and allows for it to be more personalized and for them to get to know the individual. They applied social workers, case workers, and codified cases. So if you had a case that was going to cause you to be incarcerated 90 days, it was going to make you lose your job, you were going to go back on child support, you were going to get kicked out of public housing. They combined all of those cases. And in a cost-effective manner, we're able to deliberate and adjudicate those individual cases. It just made sense. What I remembered most from the trip, and it was my second trip up there, when in the first trip, it was a young Hispanic male who had been a drug dealer because he lost his license because he was behind in child support. He wasn't good at it. He kept getting caught. So he signed up for the alternative to incarceration, and the judge looked at it, and he allowed us behind the bench, and we looked at some of his particulars, and in fact, he could go back to limo driving, which is big up there, and wanted to do so. And so he arranged it so that he would pay some of his restitution through day reporting. He would clean up alleyways and driveways, remove graffiti, and then during the day at around 12 o'clock, he would come in, get a soup, some sandwich, and then deal with his personal issues, get a GED. When he got done being sentenced, he jumped up happy. And I'm like, well, this definitely isn't CJC, Toto, this ain't Kansas. But when he got finished, he asked the judge, Judge, can you do me a favor and sentence my girlfriend? Because she doesn't have her high school diploma either. And what the judge said was yes, because any service someone accused of a crime can get in this building, people who are regular citizens can also do too, which doesn't pit individuals who run afoul of the law against individuals who often say to me, well, what do I have to do to get some particular attention? Do I have to commit a crime? Councilman Johnson, you feel that too. So we looked at that, and this is something that is unique to each neighborhood, because I'm from West Philly, Councilman Johnson's from South Philly. The issues may be similar on the surface, but when you dig down, are very different. And so that concept has to be tailor-made to community justice. Second concept that we looked at was a little closer, and I was perplexed when I found out one of the models that they're raising nationally is in Pittsburgh, in Allegheny County. And what they do is they have a day reporting center. Now, one of my colleagues, Councilwoman Blackwell, raised that issue several years back and was beaten about the head politically for raising the concept of putting forth a day reporting center. But we are at a time where we have to consider that. These individuals are not from Mars, and they will return home someday. The question becomes, will they be supervised or left unto their own devices? I would submit to those who are concerned to allow them a supervised way to re-enter the community in a meaningful way that we can guide their path. This concept they had, which was interesting, is the Allegheny Day Reporting Center. It deals with the cost of it was annually $105,000. And it reduced jail bedding, it reduced rearrest, it reduced recidivism, and diverted traditional probation and day reporting centers to a one-stop shop where individuals were treated in a case management style. The analysis took 519 offenders who received referrals to day reporting centers, taught them interview skills, employment search skills, community service skills, to close to, and now is expanded to approximately 1,200 offenders. What was interesting to me was that these individuals felt like they had immediate response to their offenses, but also felt that they were welcomed back into the community. This is not for everybody. There's some people that actually, we need to make more room for. But there are individuals that are worth fighting for and worth saving, that we need to be able to separate the wheat from the chaff. And whether you're a conservative or a liberal, it is the moral thing to do, but it is the cost-effective thing to do that I would hope that this committee takes a hard look at and that we begin to implement through our budget. What I've discovered in my research, and I'm not an expert by any means, is that most of the ingredients for these successful programs, whether you talk about Red Hook or you talk about Allegheny County, we found we have the ingredients for. Mm-hmm. What is different today is that we are breaking down silos and that we are not being turf protective, but trying to do what is in the public good. The question becomes, for me and for my colleagues, how long does good take and how much does good cost? And if we're committed to this process, we should reap the benefits of it over time. Thank you.
Thank you, Councilman Jones. What you just said is excellent, and I really think that this is something that Philadelphia could take a look at. Some of what you said is how much does it cost and what does it take, but also the social impact is clear, that it does help people become better citizens when they go through this process and get all of what they need instead of just being punitive in nature. And I think one of the things that we need to do, like you said before, is educate the public in profiling these individuals. And I will call or ask George Mosey to talk about some of the programs that the DA's office has, and also talk about who are the individuals that you are looking at going through these diversionary programs. Some of the problem is DAs are afraid to take this leap because they're looked at as being soft on crime. So could you give us the psychology around why diversionary programs are so important and who they're for?
So just to follow up on some of the things that Councilman Jones said, what's really critical to the diversion process is deciding which cases are the right cases, which individuals are the right individuals, and you can't do that without information. And so that really requires that we break down those silos, because what those silos did for the most part was they insulated us from the information that other stakeholders had. We grapple with the school district all the time about providing information, but I'm happy to say that Kevin Bethel's program is effective because he gets the information necessary to make an intelligent decision about which young people to divert. Remember, we're not talking about robbers, rapists, people who commit aggravated assault. We're talking about people who have made a bad choice, who for the most part have demonstrated to be nonviolent. But that doesn't mean that we don't need all the information that we can possibly gather about them, not just to make the right decision with regard to diversion, but to provide them with the services, the help that they need, which will be best in terms of making sure that we never see them again. I think that's the goal of everybody here. In order to do that, a diversion program has to provide supervision. You know, you talked about the day reporting centers. We established 2 in juvenile justice right here in Philadelphia, and I believe that the percentage of young people who don't show up for court, which is what they're designed to ensure, is only 5%. But what those programs do is that they do more than just supervise. They provide substantive instruction. And so it supplements what they may or may not be receiving in school. It helps to ensure that they are able to engage in wholesome activities. All those things help not just to ensure that we know where they are, but it helps to change the mindset, which is something, if not overcome, then they're not going to show up in court. And if they do, they're not going to do the things that they need to do to turn their lives around. I think case management is something that's imperative. You know, often we're talking about people who didn't know that there were resources out there that could help them. Case managers will direct them to those resources. The families as well. Family therapy. That's the kind of substantive programming, and I think the treatment has to be particularized. You know, there used to be this cookie cutter approach where everybody got the same thing. You know, you have to drop urines, even though there was no history of drug abuse. You know, so why do we have them doing urinalysis if they've never presented with that problem? So we take it a case by case, not just to make sure that it's the right kind of crime, but to make sure that we're providing the right kinds of services. When we take these approaches, and you know, I like what you said, whether your interest is purely because you want to help people or because you're concerned about your wallet, diversion makes sense. It allows prosecutors to devote their limited resources, as well as everybody else in the system. And please, let me correct you. You said these are district attorney programs. These programs would not exist unless everyone came together, collaborated. Certainly the Defender Association has been critical. The courts, critical to this process. The school district. Everybody has to come together. We have to be on the same page. We have to work it out so that there's a memorandum of understanding. And in the end, any result is attributed to all of us. And so we have been able to do that in Philadelphia. I would say that one of the best examples is with regard to drug abusers. Way back in 1997, before people started talking about drug use as a disease, Philadelphia developed the first treatment court in Pennsylvania, which allows felony drug abusers to receive treatment and to avoid a record if they'll simply work to overcome the problem that they have. One of the things that really makes these programs efficient is because we don't have to devote the time and energy to them that we otherwise would if they went to trial. You know, trial is more than just 12 people sitting in the box or a judge hearing the evidence and reaching a sentencing determination. It's also all the motions. It's the arraignment. It's the discovery. It's testing the drugs. All that can be avoided through diversion. That saves a tremendous amount of money. And what diversion does is it can expedite the release from pretrial detention or incarceration. Because if I know somebody's going to be in a program that satisfies all these needs that I was talking about, then I feel a lot safer in allowing them to leave prison. Finally, you know, you're going to hear an awful lot about boots on the street, and Kevin used that term earlier. Well, you know, Commissioner Ross is telling everybody that he's short on cops. So we have to do something to make sure that they're out there protecting us rather than sitting over in the criminal justice center drinking coffee. And if we divert the case, if they don't have to testify at that motion, at that detention hearing, at the trial, well, then they can be out there protecting us. So we identify the right people. We're assured that we're not doing it in a way that sacrifices public safety. And in the end, the hope is, and what I believe the statistics will bear out, is that we've effectively addressed the presenting problems so that we don't see these people again.
Thank you so much. You know what, let me just say, I want to thank you for just correcting me and making sure that everyone knows that this is a collaborative effort. The district attorney has a lot of power in deciding whether or not they're going to make this available to people, but it does take a collaborative effort to do it. One of the things that I also want to explain about diversion programs is that a real meaningful diversion program will also give someone a second chance if they have worked for it, meaning it will not allow someone to have a record of conviction, which kind of leads us into our last and final panelist who can talk about some of the barriers to reentry and reaching that middle-class citizenship, which people want to reach, but for the fact that now they are labeled as felons or have a lot of legislative acts that prohibit them from, you know, what we call living. And so Sharon Dietrich, could you tell us about some of the information that you, or say initiatives that you have started, or the, you know, education that you have hoped to share with all of us about those reentry barriers?
Thank you, Keir. And I want to also join all the other speakers in thanking Councilman Jones, Madam Chair, for having involved me in this important hearing today. So I'm a lawyer with Community Legal Services, and I represent the part in Keir's diagram that I think is actually not even there, but is the most important part in a way. It's the long stretch that comes after you come out of the system, because dealing with the system does not stop, not one bit, when you have completed all the steps that have been laid out today. Then there's a part called the rest of your life. And if you think that going through the system has nothing to do with that, you've successfully graduated, you are not living the experience of the hundreds of thousands of people in this city who've been through the system and still have the consequences of that every day of their life. When I came to CLS as a young employment lawyer almost 30 years ago, my God, I did the things that all the rest of the employment lawyers in Philadelphia did, most of them in the private bar, but it was the same kind of thing. We represented people in discrimination cases, we did unemployment cases, things of that nature. Now, almost all of my time is spent sitting in rooms like this, talking about criminal justice and the impact on people's employment. And a graph that we have, Stacy, thank you, that represents what I'm talking about in terms of the dire consequences on people with criminal records is CLS's intake. This is the intake in our employment operations. It represents everything that we do for people who come in with an employment-related problem, low-income people in the city of Philadelphia. The red bar is our overall intake for all kinds of employment cases. The blue bar is just cases about criminal records. People who come in and say, my record in some way, shape, or form is keeping me from getting a job, has caused me to be fired, I've got an inaccurate background check, I'm not allowed to work in the profession I trained for, on and on and on and on. And you can see that both of those bars have been rising up over time, and the more of the blue bar that we have, people with criminal records, the more the red bar that we have. It's the biggest thing that right now we do at CLS for people in Philadelphia who have employment-related problems. And I'm here to tell you that these consequences do not depend on how old your record is or how severe it is. In our experience, you cannot have a record that's old enough or minor enough that you can be guaranteed it has no impact on you. In fact, we see people every day who come to CLS for an expungement for non-convictions, because even the cases that resulted in them walking out, sometimes out of the police station, not even to arraignment. They weren't charged, but they were fingerprinted. Those are still having impact on them. People who had summary offenses from years ago. I represented a woman whose big offense was disorderly conduct, making a loud noise. I kid you not, a summary offense, also known as driving while black in the suburbs, which is how she essentially had come up with that conviction. She was fired from a good job just because she had that on her record. So that is what we are dealing at the far end of this continuum, and that's what I want to talk about a little bit today. Next slide, Stacy. So are collateral consequences a public safety matter? Absolutely, positively they are. Because when people have gone through the system, they need to be able to participate in life as those people who haven't gone through the system know it. They need jobs, they need education, they need a place to live. But 90% of employers are doing background screening. 80% of landlords, 60% of colleges and universities are asking people, do you have a criminal record? And many of them are actually going the further step and doing background screening as well. And so there's a demonstrated connection, not just based on the anecdotes that we see at CLS, lots of anecdotes, as you can tell from the numbers, but there's a wonderful paper out of Villanova University that talks about the fact of hypercriminalization in the last 2 decades has increased poverty by 20%. So there is a real connection between people living in desperate situations and having a criminal record. And people need hope. They need to know that when they've done everything that's been asked of them in the system, that they're going to be able to move forward with their lives. And unfortunately, at this point, there are too many players out there in the world of employment, of housing, of education that don't know what it means to have a criminal record. To them, you know, you got this thing on your rap sheet, you're a criminal. And so that's what we're trying to address in a lot of the systemic work that CLS has been doing and that many people in this room today are doing. So I wanted to talk about some of the recent victories. Of course, this city council, under Councilman Jones's terrific leadership, recently amended the Fair Criminal Records Screening Standard, which is a mouthful. Some people call it ban the box. I actually don't like that name at all because I feel like it doesn't give us the full breadth of what the law now does. The law specifically puts up some standards that employers have to follow in order to hire people fairly. I like to call it a fair hiring ordinance. And so, for one thing, an employer's got to make a conditional offer of a job before they do the background screening. That way, if they turn you down, you know the reason was because of your background. It requires individual assessments. You can't just say, oh, there's something on the rap sheet. It gives you some guidance as an employer about what factors you're supposed to consider. And what I think is the most important part of this law is that it has a 7-year limitation on consideration of convictions. That is huge. And it is squarely consistent with criminology research now that shows that people who have been in the system do not necessarily present heightened risk over time. If they have gone certain periods of time without recidivating, they present no more risk than the regular citizen walking down the street. So 7 years is thought of as the outside limits for many crimes like drugs or theft. Actually, the period in which you present no more risk than the rest of the population is 3 to 4 years. So why do we have employers and landlords and colleges disqualifying people for life? It just doesn't make any sense logically or from a policy basis. The next exciting thing I want to tell you about is that a couple of weeks ago, Governor Wolf signed Act 5. What Act 5 does is for the first time allows misdemeanor convictions to be sealed. That means that those employers, those landlords, those colleges do not get those convictions, those misdemeanor convictions after 10 years if you have stayed out of trouble. It is in some ways a limited law. There are many exceptions to this law as it was written, but it is the first time that Pennsylvania is allowing misdemeanors to be sealed, and at least that's an important next step. It puts us more squarely within the middle of the states in the country. There are states in this country that allow felony convictions to be expunged. We're so far from that, but at least we finally moved on to misdemeanors. That law goes into effect in November, and I hope you hear a whole lot more about the specifics of it between now and then. And finally, CLS and Pro Bono Council brought a lawsuit called Peek versus the Commonwealth, which the day before the end of 2015 ruled that lifetime bans on people being allowed to work in the healthcare industry are unconstitutional under our state constitution. Very important ruling that is going to have to be extended to other areas of the law as well. So I will leave you with some pending initiatives. A really exciting thing, there's been discussion of the bipartisan nature of criminal justice reform right now. We have our own version of that in Harrisburg right now, and you all know not a lot of bipartisan things go on in Harrisburg. Sometimes it seems like no bipartisan things, even the budget goes on in Harrisburg. But here we have a bill that was introduced, what we're calling our clean slate bill, introduced by Scott Wagner, who is a senator who's often considered one of the most conservative people in Harrisburg. And Senator Wagner, along with Anthony Williams from the city, and on the House side, Cheryl Delosier, who's also a Republican and the prime sponsor, along with Jordan Harris, also from the city of Philadelphia. They have both sponsored a bill that would automate sealing. So rather than people going into court one at a time in order to get their expungement or sealing petitions, 10 years has gone by, you have a non-violent misdemeanor, boom, it gets sealed by computer query. 5 years after your summary offense, you haven't recidivated, boom, it gets sealed by computer query. All of those non-convictions, 60 days after they're done, they are going to be sealed up. Now, that is something that could have a huge impact, and given the bipartisan nature of the support already, in the Senate already 24 people sponsored the bill, which means we're close to what we need to pass it out of that chamber. It's a very exciting prospect. The second thing I want to mention is that CLS has been having lots of conversations with people in this room and elsewhere about subsidized work. It is not, frankly, realistic to think that people are going to come out of jail and all of them get jobs in the private labor economy. Nope. Those employers who are not even giving my client who had the making a loud noise summary conviction a job are not going to be hiring people who came out of jail last week. One of the ways that we can help people with records who are facing severe barriers to work, get jobs, is to create jobs for them. And we need to talk about how we're going to make that happen. There are a lot of efforts underway at CLS to work on that. And finally, the Peek decision that found lifetime bans on employment to be unconstitutional has to be expanded into other areas where there are lifetime bans. That includes working in schools, and we're not just talking about teaching staff, we're talking about bus drivers and cafeteria workers. Many important jobs are in our schools. And also working with children, we still have lifetime bans there. Are we arguing that people who present a risk should be in those jobs? Of course not. But by the same token, we are saying that lifetime bans and lifetime consequences on people who've been through the system simply makes no sense from a public policy perspective and from a public safety perspective. So hopefully that will be one thing we address as this commission's work rolls forward. Thank you.
Thank you so much, Sharon. That was really an excellent discussion on some of the barriers to promote public safety and reentry. But also, it is an education for people to understand that there are so many people that are walking around with a record. And when we say record, we don't mean a conviction. We mean an arrest, something that didn't even delve into a conviction that can stop and people from getting jobs, housing, other viable things to keep them sustained in their communities. So we have to do more education around how that is affecting people and look at the policies that we have in place that can help. I think we are pretty much done with our panel discussion. However, I did want to talk about Julie Wertheimer, who's from the mayor's office, to talk about how we're addressing reentry also by giving people some of the tools that they need to be more productive citizens and find those jobs when they become available through the efforts of CLS.
Thank you, Kier. So a few of the things the city does, there's the Office of Reintegration Services, which is now a division under the Philadelphia prison system, which offers support services not only for those returning from our county facilities on State Road, but any Philadelphian, with a very few exceptions, returning from some form of incarceration. So we have case managers, social workers on site who do an evaluation and try to assess what the major needs and priorities are. There's cognitive behavioral therapy courses, preliminary job training. We also work with the Commission on Literacy and My Place Initiative to offer educational services. And an example of those wraparound services that we've been piloting, we have a Second Chance Act grant from the Department of Justice, and when I say we, it's a joint effort between the city, the defender, the DA, and also, of course, the courts, to help us determine individuals that can go into this program, and then it's a comprehensive wraparound service that includes a housing pilot, which is something that we haven't done before, to evaluate the efficacy of providing housing directly, knowing that this is a major challenge for a lot of individuals coming out of incarceration and a significant need especially to help them get and retain employment. In addition, there's the Philadelphia Reentry Coalition, which, while coordinated by the city, actually represents individuals at all levels of government, as well as service providers, activists, community stakeholders. Some of the leadership is here today. And they just completed last fall a strategic planning process for what reentry should look like in Philadelphia throughout the entire city, not just city government. And so they're addressing a lot of those same areas and issues that we touched on before: education, employment, housing, understanding the need for behavioral health services, trauma, addiction services, and how we can coordinate better as an entire system to address these challenges and barriers.
Thank you, Julie. It sounds like we have the making of the Red Hook model with what you're doing already, so it seems like we can combine those efforts and look at day reporting centers as a viable option. We may be able to make a huge impact. I think now we're done with our panel presentation, and so any questions? I see Councilman Johnson's light.
Thank you. First, I want to thank all my panelists, thank all of the panelists for your very informative presentations, and also thank you for moderating and keeping the dialogue and discussion moving forward, as well as my colleague, Chairman of Public Safety, Councilman Curtis Jones, and also Co-Chair, I'm going to say Deputy Commissioner Bethel. It's not the case anymore, but glad to have you back in this capacity as well, and all the panelists. One aspect I just wanted to touch on that I'm always looking at is the issue of reentry as a matter of public safety, because I'm always running into young men, old and young, who come home and they're struggling to stay on the right path. They may not have their support system. trying to figure out first and foremost how to put money in their pocket because they may be staying with a young lady. Young ladies say, hey, you stay here, you have to pay bills. They go out trying to find a job, scared to say that they have a criminal background and maybe work a little bit, then get fired after there's a background check, and so that can be discouraging. If you don't have the proper support system to keep you motivated, then it's easy when somebody come up and say, hey, we can run up in this person's house and take, something from them, or we can go rob or do something that you shouldn't be doing to make money. And so when we look at the employment barriers and begin looking at thinking outside the box, maybe more entrepreneurship programs for young men who come home. I'm always proud when I see young guys at 25th and Passyunk selling waters, right? And I'm like, at least they're selling waters as opposed to crack, to be quite frank with you. But they're taking the entrepreneurial spirit and trying to do something that's positive as opposed to something that's negative. But separate from the employment component, I want to make sure that we continue to always look at mental health, right? Because also there's a mental health and drug addiction component. A lot of these young guys self-medicate before they actually do certain crimes, or they just always self-medicating, and that plays off until when a conflict happens, they just respond as opposed to thinking because you're high on either PCP or some type of pills. But the mental health component is something definitely that we can, I would like to at least stay on the radar as we talk about re-entry and looking at criminal justice reform, but also making sure as we move forward, I know we talk about the state, but a federal discussion, because often if you come home and you take a training program in penitentiary and you come home and you're on the right path and you want to go back to college, well, you can't get financial aid if you have a felony. So you're excluded from going and following you're excluded from pursuing your higher education because you can't get financial aid. So that's something that has to be addressed on a federal level. Same thing with housing. Certain types of public housing you're just disqualified from. And you meet older individuals who need public housing that men and women have come to my office who have felonies, who are struggling, living house to house, living with friends, and that also perpetuates that cycle of crime and violence, which is a public safety issue, because if you aren't given the opportunity to rebuild your life, then you'll go back and continue doing something that's negative. And so very informative discussion to Mr. Lerner. I'm very interested in seeing how we will move forward with the grant from the MacArthur Foundation. I think that's great. I think the city of Philadelphia should be applauded for being picked, and hopefully this will become a model for other cities to follow. And at some point in time, we will have to look at how we just housing individuals as opposed to really focusing on rehabilitation and proper treatment of individuals who return back to the communities. And so just thank all of you for your dedication and your service on this critical issue. Thank you very much.
Thank you very much, Councilman Johnson. We're going to take questions, but I just want to quickly respond to some of the things you said. When you talk about reentry, we're not just talking about providing tools and resources for programming. We need to be talking about the psychology that people have. And I think that we have embarked on a very, I feel like it's going to be a positive initiative in mentoring, using the churches in a way that they understand poverty and the psychology that comes with poverty, so that the mentality of who you need to hang with, of what you need to do, and should you be living with this woman if you know you don't have the opportunity to de-escalate your anger.
But if you got kids,
well, I mean, there's sometimes you have to, you can still be a father.
Because we can also look at, and we're in agreements, so
Yeah.
we're talking about the same thing. I'm just giving real life anecdotes of what I see, but you do the same work, actually on the ground more than I do. You take child support, right? You should take care of your responsibilities, so I'm all for that, right? But you got some guys that may have done 2, 3, 4, 5 years, and the young lady that they have a child with is on public assistance. So automatically when you come home, it's called in the rears. you're already 10,000, 20,000 in debt soon as you come out.
Sure.
Right? And then you have decisions to make. Now, and that puts pressure on the person. Not skirting away their responsibility. I'm always going to say you should man up and address your responsibilities. But however, in terms of the system also put individuals who are in those type of circumstances who may have done time, want to come home and get their lives together, and they say, well, wow, I owe the government $25,000, $40,000, and the little bit of money that I'm making, they're taking half of my checks. And if I miss 1 or 2 payments, then you put me in prison. And then so that's that whole mentality kicks in, well, how do I address this in terms of surviving and still being a productive member of society? And so we're saying the same thing. And when you talk about the psychology also, and I don't want to keep going on and on, but reentry starts before the individual comes home. Reentry starts, that's why we go to Greater Fort like every other month or every 2 or 3 months, because we try to prepare some of the individuals who will be coming back home, the mentality of what to expect once they arrive back in the streets, and not in this particular case, the city of Philadelphia, but that's just my 2 cents on it.
What we've seen with the mentoring and partnering with churches is that they have the ability to address the mentality in real life situations, not away from their community or friends or relationships, but while they're dealing with the relationships that often have the adverse effect of putting them back into the same situations. So I think we should explore equipping churches and community organizations to understand how to help people with make good decisions on what you do when you feel desperate enough because you owe so much money. How do you deal with that in a realistic way? There are ways that you can go and ask someone to be reasonable about the financial burden that is placed on you and what you have. But people don't often follow those paths. Instead, they do nothing, or they go back to the point of desperation. We as criminal justice stakeholders don't have a way to deal with that in real life. But people in the community, especially mentoring and partnering with churches, do, because they can offer a real analysis of what's going on in that community. So I would suggest that we do more with that. And I see someone's, I'm sorry. This is where.
Yeah, when I think about things like that, I think about hardware and software, right? And when I talk about hardware, I talk about those things that every offender needs when they come back to a community. They're going to need a place to live. They're going to need a job. They're going to need benefits. They're going to need treatment. But then I also talk about software. I talk about those criminogenic needs that are the primary drivers of crime, the antisocial values, the companions, the criminal thinking errors that puts a person in a frame of mind that believes it's okay to engage in criminal behavior when they're responding to something that may be an external force. And I think we need to be real careful when we talk about things and not confuse responsivity issues, which are important, but they are not criminogenic needs, and they're not the primary drivers of crime. Drug treatment and employment are criminogenic needs, but they're not the primary drivers of crime. They're important, and they need to be considered. So we just, as we proceed with these discussions, we need to really keep in mind the research and what are the primary drivers of recidivism.
So, and I don't want to dominate this whole conversation, but I need you to clarify that statement for me, because when we talk about most crime being in high areas of high poverty, right, where people have a lack of education, there's a lack of employment.
Right.
Just elaborate on me the actual, if you're saying that there are actually needs but not prime drivers,
right,
just elaborate on what the actual drivers would be.
And where the research is coming from.
And
how old the research is. And who the research
So we're going to,
is.
wait a minute, because after this, we have to go to Mr. Rojas and then Mr. Cobb.
What I'm talking about is I'm talking about the cognitions, about how people think. I'm talking about the criminogenic thinking errors. I'm talking about the antisocial values, the antisocial beliefs that people have that drive the criminal thinking. Yeah. Yeah, that's what I'm talking about. I'm talking about the cognitions. Because someone is employed, because someone has a place to live, although is an important thing to have, it's sort of like which comes first, the chicken or the egg. I mean, every offender needs those things when they come back, and they're important. But it's the thinking errors that drive the recidivism. It's not the fact that the person is well off socioeconomically or have a place to live. Although they're important and do contribute, they are not the primary drivers. And I would suggest that if we look for research, we would look to the University of Cincinnati with Dr. Ed Latessa's work in that area. So.
Can I go to Mr. Rojas? You have extensive work in the
Yeah.
community, and I know you had a question or a statement. Please feel free.
I just want to first of all thank Madam Chairperson for conducting this meeting. I think you kept everybody in line. A lot of important information was imparted. But I want to go back to something that was said earlier by Mr. Lerner in terms of cultural competency. Right now, there's an issue in this city, in this country, that it's them versus us. And them versus us is driven by policies. And the mindset is, if you're not at the table, you're usually on the menu. And a lot of our kids feel that they're on the menu when it comes to the criminal justice system. My question and my challenge to everyone on this panel is, what are we doing? What kind of strategies are we using for that funnel? If you look at a funnel and certain people get through that funnel to the end, what do we do to broaden that funnel so that more persons of color are getting jobs on the front end, which is the police department and the judges, and on the back end in the probation department? The prisons is fine. Where diversity is really working at the prison. Our kids need to see a mentor. They need to see a role model that is part of the policy-making decisions in our systems. And my question to each one here is really take into consideration bringing people to the table that are from minority backgrounds, that can bring that cultural competency that's happening on the judicial side across the board to all of the departments in the criminal justice system.
Thank you so much, Mr. Ross. And I mentioned briefly an initiative that we began and we're looking at now is a mentoring partnership with Big Brother, Big Sister to service our youth when they are charged or even caught with committing an offense that's, we would say, more so immature in nature, and they can grow out of it with the right mentoring and guidance. We're using more like a grassroots initiative for people in their own community to deal with these kids and provide them with that space and opportunity to grow and make mistakes in a healthy manner. So this is it is a great program. It's not one that has gotten a lot of attention yet, but it's one that I've seen personally work really well to address the needs of youth coming into our juvenile justice system. And I would recommend that we really strongly look at that model that's still going today. It's going on in Montgomery County. Ted Qualley was a very big factor in helping bring that to fruition, and it's a good program that's helping kids way more than what the resources in the juvenile justice system we have to do as far as the psychological effect. Mr. Cobb, you had a question?
Good afternoon. Thank you, Chairperson. I think I just want to start by saying thank you to Councilman Jones for realizing that people who have been impacted by the criminal justice system need to be a part of bringing forth viable solution. So as a person who has served 6.5 years in prison for robbery, kidnapping, criminal conspiracy, and violation of the Uniform Firearms Act, I want to add a different perspective to how we actually drive this effort. What's lacking thus far, and we're only getting started, is looking at the humanity of each and every individual in which we're talking about. I know that we're talking about systems and we're talking about numbers, and it's very abstract. Some of the language that we're using are driving subliminal thoughts and subliminal biases by calling individuals offenders or inmates or felons. We're people. And if we all have the ability to keep that in mind as we lead an effort to reform our criminal justice system, our humanity will help us produce very viable outcomes. Just really briefly. So I am an expert on criminal justice reform, as it is actually my job. I have been leading criminal justice reform throughout the nation for about 15 years now. Much of what is coming out of Washington, D.C. is being led by people who are formerly impacted. President Obama has made it his mission, his legacy, to ensure that the people closest to the problem, who are closest to the solution, are literally at the table and no longer on the menu. So with saying that, I just have a question in regards to probation and parole, and whether or not they have identified ways to reduce the number of people that are reintroduced into the system that has not been able to be implemented for any reason, whether it's financial, whether it's a lack of human resources. Is there something else that's on the table? Because I think all of us are talking about reform and we're talking about reducing the number. So I just want to know if there's something that you guys have that you just haven't been able to do for any reason.
What I can talk about is I can talk about a couple of things. I can talk about our ASCR agents. And you might know some of them here in town. We have 5 ASCR agents. They're called Assessment Sanctioning Community Resource Agents, headed by a very, very good man, very good pro manager named Christian Stevens here in town. And they are parole agents that, state parole agents that do not carry caseloads. But they are tasked with being in the community, developing community resources, identifying the community resources, understanding what they are, and making them available and known to our state parole agents as they make referrals. I can also talk about what ASCR agents do in terms of running cognitive intervention groups with offenders. We run groups of medium and high-risk offenders who have a demonstrated need in terms of possessing those antisocial values and beliefs and cognitions that are the primary drivers of recidivism. And we intervene and run those groups inside each of our district offices and in other places around the city of Philadelphia and statewide. Our issue, I would say, is capacity. Our capacity of 5 state parole agents in the city of Philadelphia and about 30 statewide gives us a challenge to reach a population of 40,000. We need more community providers that provide this sort of intervention, this sort of cognitive intervention, like Thinking for Change, like the NCTI curriculum that we run, whether it's breaking barriers. It's those sorts of cognitive interventions that we need more support, in my estimation, from the community, because frankly, although it's done within the state prison to a large degree, our issues and our challenges are mainly dosage, the amount of time we have to work with someone, and the capacity to respond to that need. Frankly, if those are 2 wish list items, I would certainly give you those 2. I also want to talk about a program that we've started at the state level. It's called EPICS, Effective Practices in Community Supervision. It is a model of parole supervision that changes the paradigm of how you interact with a person. It asks a parole agent to conduct what I'll characterize as a structured parole interview. And that interview looks like this. There are 4 components. There's a check-in, there's a review, there's an intervention, and then there's homework assigned. Now, that check-in period covers the enforcement and compliance issues that a parole agent traditionally needs to cover. A review portion will cover the issues that were addressed at the previous session, at the previous meeting with the parolee, with the offender. The intervention stage is an actual cognitive intervention, a short, it's not intended to be treatment, but it's intended to be a short intervention that addresses a particular area of criminogenic need. Whether it's a side-by-side friends comparison, whether it's a cost-benefit analysis, whether it's some sort of cognitive restructuring that is engaged, but it's a short intervention. And then there is homework assigned to the offender. That model is an evidence-based model that has been proven to work up in Canada, and it's a model that is promoted and trained by the University of Cincinnati. It is something that is about the development of a skill set for a parole agent. Now that's something that I think needs to be stressed. It's development of a skill set that allows an agent to intervene with a person differently during their parole contacts. And what we've found thus far, because all I get sometimes is...
We have 5 more minutes. So I just want to make sure that one of our chairs gets a chance to, so I just want to tell you
It's just, sometimes what I get is, well, I'd like to do that evidence-based practice stuff, Rich, if I had the time. And you know what? What we have found is that the agents who have been trained and the agents who are employing the model, which takes time to learn the skills, have remained the same in the amount of time they spend with a person, but they've gotten better, they've gotten more proficient at delivering the model and delivering the intervention. Now it's not the type of training, like I said, it's not the type of stuff that you can just go for 3 days and learn it. It's something that needs practice, that needs coaching, because it really, really changes the paradigm of how we interact with people. And I think it's going to produce some positive results, but it's not an overnight change. It's not an overnight change. It's about the development of a skill set for our parole agents, and frankly, that's challenging.
Thank you so much. And I agree with you. You're right. Some of the language that we use does help to keep the labeling and the kind of public perception going. I know as far as juveniles go, we used to call young girls who are charged or who are found to be in violation of or performing sex acts, we used to call them prostitutes. Now we've changed that thought that we should not be calling young girls who are 10 and 11, 12 years old prostitutes. We need to be calling them victims. And that has changed the way we look at what we do with them, even if by sticking them in the system or by giving them services. So some of the things that we say need to do have an adverse effect, and we really need to examine some of our language. I'm going to let this discussion close out with our co-chair, Tariq El-Shabazz. After that, I want to thank everyone for participating, and Tariq, the stage is yours.
Thank you. First of all, I want to thank everyone for... First, I want to thank everyone for participating in something that I believe is very, very important, but I want us to remember at least 3 things as we gather together to try to come up with a solution to a problem that didn't create itself overnight and that has many facets and many factors. And I began by saying many facets and many factors because it's not one thing. It's not the person that's just unable to pay the bills or the person that is behind because they were in prison in child support or the person that has the drug addiction, but there are different factors and different reasons why people do the things that they do. And if we understood it from a psychological, a psychiatric, from a social standpoint, we wouldn't be in the condition that we are now. That's the first thing. The second thing is Judge Lerner said something that I thought was tremendously important, and it's very important for people on this committee. Absolutely important for people on this committee. He said, you know, what I found when I went to the judges' diversity, I would say, workshops, is that, you know, those that felt they were liberal weren't as liberal as they are, and those that thought they were conservative was probably more liberal than they were conservative, or maybe even more conservative than they were. What that says is that we have to be open enough to relieve ourselves from ideas of institutionalized socialization, since we want to use big words, or just being indoctrinated in what we're talking about. Open enough to listen to somebody who may be a little different than us, and their experience may be a little different than our experience. And if we put those experiences together as a collective group, we'll come up with some solutions that we'll be able to identify. And that gets to my last point. We talked about communication. That's all you were talking about. And that's all what my brother behind me was talking about as well. We can't begin to have a conversation with someone who only understands Italian by speaking to them in English. We have to first understand Italian. Then we can have a conversation with them. So in order to understand why someone does what they do, we need to kind of find out where they come from. I think that was said by many members of the panel. So we can't begin to use language that is offensive to some, but when we look at it in our institutions of higher learning, it's how we learned and what we found. For example, offenders. People are offended by that. Behind the wall. I know what it means, other people know what it means, but when you talk about putting somebody else behind the wall, that is an issue. The conversations we need to begin to have is, why does someone do what they do? One of the best ways to find out about it is go where they are. Talk to them. Talk to people that know them or people that are in those communities. When I asked about the research and where the research was from, that's because that research that you cited in Cincinnati is different from the research in Bedford-Stuyvesant, Brooklyn, New York, in Red Hook, Brooklyn, New York, in North Philadelphia, in West Philadelphia, in Northwest Philadelphia, in South Philadelphia. Research needs to be done there because there are a community of people who have some things to say, but no one is listening. And sometimes it's because the way they articulate what the issue is not being received because they're speaking Spanish and people are only understanding Italian. And so what I asked us to do is to be open to everyone's particular position, to be open and receptive to receive the information that they give us so that we can use their information with our education and our information to come to a group solution. And we can only do that by being conscious of what we say, how we say it, how we demonstrate it, and what we're really here to do. And that's the only final comments that I had to say with respect to that. I think this is a great start, but it didn't happen overnight. And folks, it's not going to be, it is not going to be solved overnight. This is an age-old problem that we allowed to get out of hand. Now we have to begin to peel away the banana peel to get to the fruit. That's it. Thank you.
Madam Chair, so under our format, are we doing public testimony Monday, or are we allowing some today? Which one? Oh, okay. So I think I understood. So there is a general open mic on Monday, and we have scripted. Okay. So we have folk that are going to testify as experts in the field to put it on the record today at 2. Is this, all right, so again, so Madam Moderator, I'm going to turn it over to you. What are we doing?
The next panel discussion is going to be on prevention. And however, for public testimony as related to this topic will be held on Monday. And
you have to turn your mic on.
Coming at 2 o'clock, that will be
Yeah.
on the expert panel.
yes, as far as for prevention strategies and short-term goals.
Yes.
Yes.
Thank you, Madam Moderator.
Councilman Jones.
So are we recessing? Yes. So we are recessing this hearing until 2 p.m. today in these chambers. Thank you all very much.